Awesome. That's
Where's up
awesome.
there? So this, I told myself.
Okay, good morning, everyone. It is Happy Monday, March 22nd, 2021. Today we are gathered here for a workshop, and the purpose of the workshop is legal issues and best practices, LGBTQ+. It's approximately 3 hours, and then we have good of the order and an adjournment. And if you will please introduce yourself as you go for the record, and thank you all for being here. And whoever would like to start.
All right. Good morning, and I think I'll take this. I think that's a great way to start is by introducing each of the members up here, and I guess I'll start with Crystal.
My name is Crystal Torres Nunez. I'm the Diversity and Inclusion Coach for the Lee County School District. Good morning and welcome, everyone.
Good morning.
Good morning. I'm Chuck Bradley. I'm Director of Positive Prevention and serve as the Student Equity Coordinator for the district.
And good morning again. I'm Brian Williams. I'm the Chief Staff Attorney for the school district.
Good morning. My name is Christine Schroed, and I'm a staff attorney under Academic Services.
Good morning. My name is Ryan Hudak. I'm the coordinator of the Office of Civil Rights and Equity for the district.
Thank you.
All right, and we'll jump right in. And I think right now we just want to show you an overview of what we're going to present here today and talk about some of the issues that will be coming up. Essentially, every student has the right to learn in a safe and accepting school environment. This includes LGBTQ+ students. Schools must respect the rights of LGBTQ students, as well as the rights of other students and parents with regard to their freedom of religion and expression. That is a balancing act that requires a case-by-case analysis, and you're going to hear that a lot today, right? There's a case-by-case analysis. I think oftentimes when it comes to law, we want to make things black and white, and sometimes there's a little gray in there, and it requires an interpretation as well as the assistance of both staff and legal department, as well as the parents and students in terms of getting to the right solution. The laws are new and evolving. The majority of emerging case law supports the rights of LGBTQ plus students. LCSD follows current case law trends and best practices in formulating processes with respect to LGBTQ plus students in the school setting.
Excuse me, Madam Chair. Can I ask you all to please move your microphones closer to your mouths so that I can not miss a word? Thank you.
No worries.
Just had them turn it up also.
Thank you.
So first we wanted to start off with an overview of the federal laws as it relates to the issues that we'll be discussing today. And here we have the United States Constitution. And first up we have the First Amendment, which protects the rights of students to free speech and freedom of expression. This would include sexual orientation, gender identity, and gender expression. Then we have the 14th Amendment, equal protection, which protects the students' rights to due process and equal protection and imposes a duty on schools to protect LGBTQ plus students from bullying and harassment, just as it would protect other students on the same basis. Continuing with the federal laws, we have Title VII of the 1964 Civil Rights Act, which prohibits discrimination on the basis of sex and has been further extended to include transgender status. You're going to hear about this today's presentation, the Bostock case versus Clayton County, which was a recently decided Supreme Court case, which furthers the rights of transgender students as it relates to these issues. Title VII case law is now being applied to Title IX discrimination against LGBTQ plus students, such as restroom usage. And again, you'll hear more about that in our presentation, but we felt that it was important to share with you the way in which Title VII is being applied to these issues. Title IX of the Education Amendments Act of 1972 prohibits discrimination on the basis of sex in any education program or activity that receives federal funds. Of note, Title IX does prohibit gender-based harassment, such as harassment on the basis of a student's failure to conform to stereotyped notions of masculinity and femininity. Oftentimes, you're going to see these issues come up with the Office of Civil Rights, and again, it's a topic that we'll be discussing later on today. Then you have FERPA, the Family and Educational Rights and Privacy Act, which protects the privacy of student records. Moving into our state laws, we have the Florida Constitution. I'm going to read Article 9, which the education of children is a fundamental value of the people of the state of Florida. It is therefore a paramount duty of the state to make adequate provision for the education of all children residing within its borders. I underline all because it's taking into consideration all of our students and all of the categories that they fall into. Adequate provision shall be made by law for a uniform, efficient, safe, secure, and high-quality system of free public schools that allows students to obtain a high-quality education. Again, Article 1 discusses the rights of privacy, which we will get into in our presentation later on. And then I wanted to include the Florida Anti-Discrimination Law as well as Jeffrey Johnson's Stand Up for All Students Act. These are laws which specifically address discrimination as well as bullying that typically fall into a lot of issues that we see as it relates to our LGBTQ plus community. Next slide. Again, here we are with the Florida Principles of Professional Conduct for the Education Profession. I'm not going to go in and read this whole thing here, but essentially the common theme is that obligation to the students requires that individuals shall not harass or discriminate against any student on the basis of race, color, religion, sex, age, national or ethnic origin, political beliefs, marital status, handicapping conditions, sexual orientation, or social and family background, and shall make reasonable efforts to assure that each student is protected from harassment or discrimination. So again, consistent with the theme throughout. Here we have several proposed state legislations, including the Parents' Rights Bill, passed in the House but died in the Senate. We have the HB 935, which criminalizes medical services provided to transgender minors and prohibits transgender girls from participation in girls' sports. And then SB 2012, promoting equality of athletic opportunity. We're going to get into some of these specific topics later on in the presentation, but we felt it pertinent for you to have this information so you could have the context of the issues that we're discussing. Last but not least, we have LCSD's board policies. As you know, we recently updated our non-discrimination and bullying and harassment policies that now protect students and employees based on sex, sexual orientation, gender identity, and gender expression. That's critical because here we have federal law, state law, and now local law in terms of our board policy, all which goes towards preventing discrimination with respect to our LGBTQ plus community.
And that being said, I was going to go over the policies. These policies were in place prior, but they've been revised and updated since the inception of the Office of Civil Rights and Equity. They were recently updated to encompass wider protection of protected classes, as well as transparency for individuals that may belong to that protected class. Both of these policies were approved in 2020. The first one on the slide now is policy 1.27, which was expanded to include not only sex and sexual orientation as it did prior, but also it includes now gender identity and gender expression. It also included other updates such as GINA and anti-Semitism, but relative to LGBTQ+, gender identity and gender expression would be the main changes or revisions of the non-discrimination policy. This policy is available online, as well as how to file a complaint if any staff or student feels they are discriminated based on one of these protected classes. It's also posted in all classrooms throughout the district, as well as all departments throughout the district in English, Spanish, and Creole. This policy was approved in June of 2020. The next policy is 4.14, which is the bullying harassment policy. This is required by the Jeffrey Johnson Stand Up for All Students Act. It is required per statute to be revised every 3 years, per statute 1006.147. During this revision, the statute requires that it needs input from various community members and groups before being approved. Office of Civil Rights and Equity did reach out to various community organizations, as well as student organizations and parent organizations, inquiring about the policy and giving them the chance to review any updates. That being said, there weren't many significant changes to the policy, as the Florida Department of Education does have a template with criteria that is required for this, and you can see throughout the state, many districts use the same boilerplate policy with their own individual inclusions in it. The main distinction for this presentation for LGBTQ+ individuals is that the district included or mirrored the language from the non-discrimination policy, as you can see here, bullet point number 8, that includes gender identity and gender expression. This policy was approved in October of 2020. The next slide goes over the Office of Civil Rights and Equity. There was a Dear Colleague letter in 2016 issued that gave guidance on transgender students within the schools. This guidance came because there was many questions from different parents, principals, and school districts to OCR inquiring what the rights of transgender individuals are. So this Dear Colleague letter provided information stating that they could not force the transgender student to use a bathroom they did not identify with, as well as they did not have to provide medical documentation for a student's transgender status. This guidance was rescinded in 2017. There was no replacement for this guidance under the Trump administration. That being said, this guidance does not have the effect of law, but again, it was just guidance for individuals. Questions were arising in this topic. In 2021, since President Biden was elected, there have been a couple executive orders regarding the transgender rights and LGBTQ+ rights of individuals. These two executive orders are here. The first one is 13988. This one enforced the Bostock decision, where the Supreme Court held Title VII's prohibition on discrimination because of sex covers discrimination on the basis of gender identity as well as sexual orientation. The order also states that laws that prohibit sex discrimination, including Title IX, prohibit discrimination on the basis of gender identity or sexual orientation, so long as the laws do not contain sufficient indications to the contrary. The most recent executive order was passed the beginning of March. That is Executive Order 14021. This gives the Secretary of Education 100 days to review the regulations and orders and guidance regarding discrimination on the basis of sex, which would be Title IX. The DeVos administration did make significant changes to Title IX process for sexual harassment that were implemented in August of 2020. And this was under scrutiny, so I don't want to speculate, but they have 100 days to review and revise anything in Title IX or discrimination on the basis of sex to determine if anything needs rescinded or revised in these policies. And currently, I just want to state that Title IX does not explicitly say sexual orientation or gender identity, nor does it say biological sex.
All right, and next up, we're going to jump right into student privacy issues. Now, this is probably one of the biggest elephants in the room, so I'm going to just jump right in and address it. I think that when discussing student privacy issues, we have to take into consideration multiple issues, including the privacy interests of the student as an individual, as well as the privacy issues related to the parents involved. And I think that one of the first places to start with respect to this is student records and student information that may be contained in those records. As we discussed earlier, we have FERPA, and as it applies, a parent is entitled to any information that is contained in that student's records, educational records. I think that's well established. I don't think our district is taking any position to the contrary to that. And so if there's information, including information relative to the transgender status of that student, if that is contained in the educational record, the parent has a right to access to that information. That being said, if it is not contained in the student record, then we have a different analysis. And I want to be very clear that that individual student does have a privacy right to information that is not contained in their student record. In this instance, their transgender status or sexual orientation. And I think this is one of those situations where our schools often struggle in terms of understanding what information can be shared and what information cannot be shared. And again, as you get to this topic, our district is taking an approach similar to a lot of districts statewide, that this is an opportunity to engage all parties involved. I think it's easy to look at create a bright line and say either you disclose or you don't disclose. Our goal here is to do what's in the best interest of the student while also following the law, and that involves trying to take a proactive approach and engaging both the student as well as the parent in trying to share this information to the extent that we legally can. I want to also make it clear that there are exceptions to the privacy rights of that student, and that can be if there's a potential for safety and welfare or harm to the student or to someone else. That is an exception where the school can absolutely tell the parent if necessary. Another considering factor is the age of the student. We have students coming out transgender in elementary school these days, and so the age of the student can dictate whether or not the school has a right to share that information with the parents. And ultimately, we get to what's on the slide, whether or not a compelling interest exists such that the school should notify the parents. And again, that's a case-by-case analysis. There's not a bright line. It's either this or that. And I think our schools and our staff are taking the approach that we are looking at those issues and trying to get to the right solution in light of the information that is presented. Again, as it relates to student privacy issues, this is a very difficult topic that I know is difficult for folks to understand on both sides of the issue, but we're taking into consideration not only the parents' rights, but again, the rights of that student. I'm going to go right to the student privacy issues, which, again, here are some of the requirements of when you would disclose that information, including the duty to ensure student safety, principles of professional conduct for the education profession in Florida, as well as the ethical standards for mental health professionals. I anticipate some questions on this later, but I really just wanted to kind of throw that one right out there, and again, we will be more than welcome to answer questions a little bit later.
Okay, and there's a lot of talk about transgender students that is emerging, as Mr. Williams said. First off, a lot of discussion about how you refer to transgender students. Per the Grimm case, students should be called the names and pronouns that they prefer. If they so request, it should also be included in the online record system. I know Crystal will be talking about GSAs. There is a case out of Florida that discussed that. The school district there passed a rule that restricted middle school clubs to curricular themed, thereby denying the GSA club in their school. The court said that any public secondary school that receives federal financial assistance and permits non-curricular student groups to use school facilities must provide that equal access to other groups. It also held, notably, that since middle school offered high school programs, it qualified under the as a secondary school under Florida law, so that also permitted them to have that GSA club in the school setting. This is obviously another very hot topic. I can say with certainty that the vast majority of cases right now support allowing the transgender students to use the restrooms and locker rooms of the gender with which they identify. It's still evolving and emerging. Oh, sorry, thank you. We have the Grimm case, which we referred to before, and in this case, a transgender male sued the school district when they enacted a policy that prevented him from using the bathroom consistent with his gender identity. It went back and forth, was eventually remanded back to the appellate court or the circuit court, and they found that it was a violation of the student's 14th Amendment right and Title IX. So in that case, they were interpreting Title IX similar to how Bostock interpreted Title VII. You know, again, that is further supporting the rights of transgender students to use the restrooms of their choice. Here in Florida, we have the Adams case. This was in the Middle District of Florida. And the same issue, transgender male student was using the male bathroom. Another student complained. The transgender student actually had obtained an amended birth certificate and driver's license in this case, indicating that he was male. The court found that the student identified as male, is identified by others as male, and is legally deemed by the state of Florida to be male, and is otherwise treated as male, except for the school district not allowing him to use the restroom of his choice. The current state of this case is the school board appealed to the 11th Circuit in 2020, and the lower court decision was affirmed, holding that a public school may not punish its students for gender nonconformity. And neither may a public school harm transgender students by establishing arbitrary separate rules for their bathroom use. So again, it further held that the school's bathroom policy constituted discrimination on the basis of sex. So again, we're seeing that Title IX applied in the same way as Title VII, and it's cited to that Bostock decision. So it's still pending. The school district there has requested an en banc hearing in front of the Supreme Court, and the request remains pending as of today. Another topic that I know a lot of people are following is transgender students and athletic participation. We are part of the Florida High School Athletic Association, and therefore we follow their policy. I'm not going to read the policy, it's quite long, but that is how we handle those issues at this time. As Mr. Williams stated, there is pending proposed legislation trying to kind of reverse this policy and prohibit girls from participating, or transgender females from participating in girls' sports. But again, it's kind of unclear right now. Okay. So I believe Mr. Bradley has the next slide. This goes into how this looks in the school district.
Good morning. So at this time, we just wanted to talk about where we are in terms of supporting our LGBTQ+ students and responding to questions that we've received, both from the community and from the board, in terms of what we're doing. So we want to reiterate that at this time, there is no LGBT+Q curriculum. We, as a school district, teach the Florida Next Generation Sunshine State Standards in all of our accredited courses and coursework in the district, or related coursework such as IB, AP, et cetera. We do address issues that arise on an individual case-by-case basis, and so as students express concerns, we are addressing those concerns and helping our students to support them so that they can remain engaged in their academics, and that is the primary purpose of our support for them. So we do provide supports to all students as well. This is not targeted specifically to just LGBTQ+, but to all students who need support. We do encourage and provide that support. We do follow our board policies in prohibiting harassment and discrimination, and that is on all fronts. So all students are protected under our non-discrimination policy, and we ensure that our policies, the policies of the school district, are enacted fairly for all students.
So I'm just going to speak to you briefly about our support for our student-led organizations, or our GSAs. So, of course, our student-led organizations are voluntary student-led organizations or clubs that build community and organize around issues that may be faced by our students in their schools and communities. Some of our GSAs are identified as equality, unity, or identity clubs outside of just the traditional name for a GSA. Of course, our student-led organizations all follow the same guidelines that our district has for all other clubs and organizations. So the students approach with an interest of starting a club or an organization, and then from there, they seek out a sponsor with a faculty member. Once they've identified a faculty member as a sponsor, they will then go on and have the conversation with administration about their interest of having that specific club or organization on campus. And then they will consult with any school-based activities that that club or organization may participate in. Currently, in our high schools, we have established 7 GSAs, so half of our high schools currently have a GSA. Some of those GSAs have been long-standing for 5+ years. We actually have one school that has reached out, and they're interested in, and we're in progress of working with them on establishing a GSA at their high school. Currently in our middle schools, we have 4 middle schools with established GSAs that have been going. 2 of those middle schools, one of those middle schools has been going for a couple years now. One is newer. And then we have one middle school that is interested in starting and working on establishing a GSA because students have approached with an interest for it. We also provide some level of training and professional development for our district level staff as well as school-based leadership and staff. So these are just some of the trainings and professional development opportunities that we work in conjunction with diversity and inclusion, as well as positive prevention and our civil rights and equity department, to ensure that there's a level of understanding compliance, our non-discrimination policies and the protected classes, Title IX, and our bullying harassment. We do provide this on an annual basis to our equity coordinators and any other school-based staff that will be working directly in ensuring that we have equitable practices going on in the school. And I'm going to pass it back over to Chuck.
All right, so at this time, we'd just like to share with you the current Title IX processes, and Mr. Hudak referred to our policy, our non-discrimination policy previously. So discrimination falls under various title support from the federal government. Title IX covers sex and sexual harassment, including sexual orientation, sexual identity. And so we use a combined complaint process and this form is available online. So if a student or staff member is experiencing sexual harassment or discrimination based on sex, they can file this complaint form, and it does come to Mr. Hudak and myself, and depending on whether it's for student or adult student or staff, which goes to Mr. Hudak. They also have the right to file complaints to the Office of Civil Rights and the EEOC in terms of seeking relief for their complaint. The complaint process is found on our website. It's under our non-discrimination policy. Those complaint forms are available there at that site, as well as there is a second page specifically for Title IX and a third one for Section 504. The Title IX page includes the supports that we've put in place for Title IX, and this was in response to the DeVos administration requirements to improve our complaint and complaint resolution processes. Specifically on this page, you'll find the training videos or PowerPoints that were provided to those who are required to respond to Title IX complaints. For a school-based Title IX complaint, the complaint is forwarded to the equity coordinator, and from there the equity coordinator receives and triages the complaint. At that point, the complaint is either dismissed or investigated by a school-based investigator. It's a thorough investigation. We're taking responses from all witnesses, as well as the reporter and the responder, and determining if all facts have been presented. Once that is concluded, then it goes to the decision maker of the school to make a final decision of whether it's substantiated or unsubstantiated. So the DeVos administration really divided these roles out and requires a thorough treatment of that Title IX complaint. All of that is specified here on our page. In our Code of Conduct for Students this past year, we did put information about Title IX and what all students need to know about Title IX, particularly about discrimination based on sex or sexual harassment. And this page then serves as information on how to seek relief as well. We also put in place documents for best practices and action steps, many of those which were outlined in the presentation from the legal portion of this presentation in terms of the inclusion of our LGBTQ students in activities at school, athletics, the way that they dress according to our, as long as it's within our code of conduct for our dress code, that they have the right to dress according to their gender identity, use of restrooms, privacy of their information, participation in activities, etc. A copy of the non-discrimination policy is also included on the poster, as well as some brief definitions and access to information for students who may need support outside of the school district, who may be in crisis or need that mental health support. We've also included a local version of safe space stickers. This is nothing new to the school district of Lee County. Safe space stickers have been used here for the better part of a decade. But this is in particular the first school district of Lee County branded sticker. And particularly it was created because the other stickers were just too expensive to purchase any longer. But they do indicate a safe space in which LGBTQ plus students and all students can find access to a caring adult who can help them and help them gain access to resources or to support that they may need to continue their schooling. This year, we also had a number of students that have come forward and have said that they want to be addressed by their gender-affirming name. These are mostly our transgender students who have made this request, and many at the support of their parents. And so this year we have worked, particularly with the COVID-19 and with the use of distance learning, became difficult to find ways to make sure that these students were supported in their classrooms. And so this year we put in place a simple process in which a student who is making this assertion that they want to be addressed by their gender-affirming name, meet with a counselor, and to create what is known as a gender support plan. Basically, the gender support plan just talks through all of the situations that can occur on a campus or during their schooling, and ensuring that the student also meets somewhat of a standard in terms of their assertion that it's insistent, consistent, and persistent. And when that standard is met, and when that information is collected by the counselor, then that student can get supports on campus in terms of supporting their gender identity. And that includes having their pronouns used, their gender-affirming name used, as well as having that populate within certain district applications that do not require a legal name to show up in that application. This last year, Mr. Hudak and I also worked on creating several procedural guides in putting together the Title IX procedural guide that included all the processes previously described, as well as we revised our bullying and harassment reporting and investigation manual to mirror the same. And so currently all of our bullying and harassment reporting tools are located in focus for our practitioners to use at the school-based level. At this time, I'll turn it over to Ms. Schroed.
Okay, I think we're going to open it up for questions.
Okay. May I have a hands of who has any questions regarding the presentation thus far? Ms. Vaughn, please.
Hi. Okay, I realize we, excuse me, I realize we don't have LGBTQ curriculum per se. However, we do have health education, and I would like to know if these kinds of issues are dealt with in our health education curriculum, in the sexuality portion.
And I'm not personally prepared to provide a response to that. Ms. Leisha Roy would be the person that can
Yes,
respond.
I'm sorry, I can't barely hear you.
Yeah, Ms. Roy is here, so I was
she's
just going to
walking
suggest
up.
that we call her, she's the expert on health education.
I thought it might be a good idea for me to show up as this one.
Thank you for being here.
And she's the expert on all of these health education matters. Thanks, Leisha.
So, as far as the health education curriculum, I didn't turn it on. I talk really loud, so I don't know that. Is that better?
Yeah, we can hear you.
Okay. As far as like the curriculum maps and what is actually in those, there is not an identified section for that, but I promise you, any prudent health education teacher is going to be prepared, because even if they were not bringing it up as part of the curriculum, it gets brought up. Whether it's in the sex education section, bullying prevention, and it's not just at the high school. I mean, it's down. I've got teachers contacting me at the elementary level, wanting to know how to address when a third grader says, "What does this mean?" Usually you just give them the answer. Here's the definition for sexual orientation. They're like, "Okay," and they move on. There is not, at this point, guidance in statute, but I can assure you that the Office of Healthy Schools, this is a big push that, again, not using opinions, not, just here are the facts. This is what this means. And again, it's not just in the area of sex education. It also plays in the role of bullying prevention, healthy relationships, respect, and character type things. So does that answer your question?
Yeah, and this has been a huge issue with many constituents that I've had to address a couple times. So there's no, if it is taught, And I heard what you said, that it isn't part of the sexuality education unit. What grades might this be appropriate to teach it in? Because
I'm not sure what you mean as far as.
well, in other words, where would it fit in the best? Or if we expand our curriculum maps to include this as a topic, what grade levels would be most appropriate to
Just like
include
everything
this?
else, and we've discussed this with the board for many years, waiting till they're much older, they may have completely incorrect information up to that point. So at minimum, you would want to start this at early middle school. I absolutely think that, if an elementary child asks the question, what does gender identity mean? And simply giving them, hey, that's what this means. Again, you're not sharing an opinion, you're not going into any other depth. It's the curiosity, and if they don't get that information from us, they're going to get that from elsewhere, and that information may not be correct and may be very biased.
Yeah, and I agree 100% with what you're saying, but it is a huge issue in this county, and not only among parents, but also other very conservative constituents. So I just wanted to kind of put it out there that we are not, because I think some people have the mistaken belief that when a question like that is answered, that we are encouraging something or promoting something. And I'm glad you said it the way you did, because that's a very mistaken belief. And of course, don't the parents still have the right that if they're uncomfortable with a particular unit, that they can have their child opt out?
Sex education and the disease prevention, they do have that option. Again, this may come up in bullying prevention. I can tell you that avoidance, 28 years in now, avoidance of these questions from kids tends to cause, it ramps up their curiosity. So, if it's handled just like anything else. I mean, if you ask me what a heterosexual is, no one would question that. So I think if we can make sure that our staff is educated to make sure they keep their own personal biases out, I can't see it as being anything but a positive.
Yeah, and again, I totally agree, but I wanted to be sure to put it out there because of many misconceptions that I have heard from constituents, and again, not just parents, but other interested parties in Lee County. So thank you for explaining. That's it.
Ms. Patrica?
I have a lot of questions, so please stop me and move on to others and then come back to me as you find appropriate, because I do have a lot of questions. And mostly it's helping me to understand, because I've talked to a lot of people in the community about this issue, and I've told them I'm waiting for this workshop so that I can understand how we're dealing with it in our schools before I form an opinion as a board member and as a parent as to my level of comfort. So there is a lot that I don't understand, and I'm sort of going through this slide by slide. On slide 4, we talk about a lot of cases. Has the Supreme Court ruled on this specific issue with regard to how we treat these issues in public schools?
I can speak as far as, the use of bathrooms. No, it's like I said, the Grimm, I believe the St. John's case, they're appealing. The Supreme Court has rejected in the past these cases that have come before them. They have decided not to take them. In my opinion, I feel like it would be more beneficial for a lot of school districts who are struggling with this issue for them to provide guidance once and for all. But like I said, the vast majority of federal case law supports the use of transgender students using the bathroom of the gender they identify with. So that's why we are following that trend at this point. It could change. So that's where we are right now.
What I didn't see in those cases, I mean, I see the comparison between Title VII and Title IX, but Title VII is an employment law dealing with adults. And Title IX deals with children under the age of 18. And when we're talking about children under the age of 18, the parental rights issue is present, and that's not an issue that's present under Title VII. And I haven't seen that addressed in any of the analysis when we're trying to bring Title VII case law into our anticipated interpretation of Title IX case law. And that's where I have the biggest issue with all of this is parents' rights. Where are the parents' rights to direct these conversations and to be part of decision-making and all of that? So that's my concern when we say this is the trend. Well, I would think that the Supreme Court would also look at the fact that we're dealing with children and parents have a right to be a part of this decision-making in these conversations, right? Does that make sense?
Sure, it makes a lot of sense. And in my previous district, we did have some guidance from the Seventh Circuit. It was decided on this issue in that court. It was Whitaker case. It did apply Title IX in the same way as Title VII in determining that sex discrimination applies to sexual orientation, gender identity, all of that. So there are several cases across the country that have interpreted Title IX that way. There are some cases, a couple of cases that have not. But like I said, I believe the overwhelming majority are interpreting it that way, even if that wasn't the original intent.
And I think the other distinction between the two as well is, again, Title VII employment law, Title IX specifically contemplates and addresses these intimate settings like locker rooms and restrooms, making sure that there's equality there between girls' facilities, boys' facilities, women's facilities, men's facilities. And so because the law specifically addresses that, I would think you would need a change in the law in order to change how those facilities are used, as opposed to an interpretation based on Title VII that includes no mention of those things whatsoever. Am I making sense?
Yeah, I mean, I understand the need for actual, more specific guidance. I think I completely understand that, and I think a lot of school districts are struggling with this as well. Unfortunately, all we have to go on is, our guidance from OCR, executive orders, and federal case law at this point, interpreting Title IX and Title VII similarly.
Can I keep going?
You have 2 more questions.
Okay, I've got a bunch more after that, but I know that I've had this conversation with at least some of you. When the original guidance came out under President Obama regarding restrooms and locker rooms, my daughter, I think, was in middle school at the time, and she would get off the bus, I would pick her up from the bus, and I would bring her to FGCU for swim practice, and she would change in the locker room at FGCU. And in order to put on your swimsuit, you have to strip down completely. And the level of discomfort that I had, knowing that my daughter could be exposed to another sex in the locker room was huge. And I wondered, where are my rights as a parent to protect my daughter from that? And I think that's the concern of a lot of the parents that I'm talking to here, is these intimate settings that involve significant privacy rights, as far as I can tell, are at issue here. And I'm not sure how we walk through that without violating, on the one hand, the transgender students' rights, or on the other hand, violating the student who feels uncomfortable in that setting and that parent's right. Am I making sense?
Can I respond real quick?
Sure.
So one thing, Ms. Patrica, that we do have in our guidance, and this is in our best practices document as well, is that all students have the right to use the restroom of the gender with which they identify, or seek an accommodation for a gender-neutral restroom. That applies to all students, not just LGBTQ. So if a cisgendered student is uncomfortable going into a restroom where they know a transgender student is, they also have that right to seek out a gender-neutral restroom.
So my daughter would have to seek out a different restroom
They have the right to use either, as all
if she
students
felt
do.
uncomfortable changing around.
And Ms. Patrica, I can expand on how other school districts have handled this issue. And, I mean, this is kind of looking forward, but I know where I came from, they were starting to outfit schools with individual stalls, changing stalls, so that all students can have that privacy when they're getting changed and in that intimate setting. So that is definitely something that could be addressed.
Okay, you can come back to me.
Okay. Anyone else? Ms. Mary?
So I don't have any questions, but I'd like to ask permission to read a very short elementary book. And I just want to say, as an elementary school counselor for 30-some-odd years, none of this is new to me. And so I have dealt with these issues many times over the years. My own children and grandchildren have grown up in a house with boys and girls, and we all use the same bathroom. I recently went to a public place, and when I went to use the restroom, it's no gender identification, it's just the restroom. So I think that we're moving more in that direction. But I came upon this little book, and I just thought it really puts it all into a very simple explanation regarding those issues regarding restrooms and changing rooms. So this is called Jacob's Room to Choose. And the reason I picked it up is because I have a great-grandson named Jacob, and I really didn't know what it was about when I started to read it. It is written by the parents of a transgender student. The carpet was warm, the bunnies were funny, Jacob and Sophie loved library time. And I didn't, may I?
Yeah, please.
Okay. Okay, kids, said Mrs. Reeves, we've got 10 minutes left. Does anyone need to use the bathroom before we head back to class? Jacob and Sophie raised their hands. And I'm not going to tell you which one is Jacob and which one is Sophie, but this is the way kids look in school today. So they stopped outside the bathroom doors. Do you think it's okay? Asked Sophie. I don't know, said Jacob. Sophie walked through one door. Jacob took a deep breath and walked through the other door. Two boys were at the sinks. They stared at Jacob standing in the doorway. Jacob knew what that look meant. He turned and ran out. Jacob stood in the hall, his heart pounding. Just then, Sophie ran out of her bathroom. It was hard for Jacob to talk. Did you get chased out? Sophie asked. Back at the library, Sophie shifted from foot to foot. I need to use the bathroom, she said. Mrs. Reeves was confused. Didn't you and Jacob just go to the bathroom? Sophie squeezed her eyes shut against the tears. They wouldn't let her, said Jacob. They said she had to use the boys' room. Mrs. Reeves looked inside the bathroom. It was empty. Anybody in there? There was no response. She waited in the hall while Sophie and Jacob went in. Better? Asked Mrs. Reeves. Yes, said Sophie. Has this happened before? Sophie and Jacob glanced at each other. Usually, I don't go at school, said Jacob. Sophie started to cry again. It's not fair, said Sophie. No, agreed Mrs. Reeves. She gave them both a hug. It isn't. Back in the classroom, Mrs. Reeves drew on the board. What do these pictures mean? Boys and girls. One has long hair and a little dress, and the other has short hair and pants. Okay, Mrs. Reeves said, but how do you know? Well, the girl has long hair, said Emily, and she's wearing a dress. The boy is wearing shorts, said Noah, and a t-shirt. Now I want each of you to stand near the picture that looks like you, said Mrs. Reeves. Jacob and Sophie looked back at Mrs. Reeves. Mrs. Reeves winked. Hold on. Noah, you have long hair. That sign shows short hair. And Emily, you're wearing pants, but the person on that sign is wearing a dress. Mrs. Reeves scratched her head. Why don't you switch places? Noah shrugged and walked to where Mrs. Reeves pointed. Emily looked at the group of boys. I don't want to stand there, she said. Why not? Asked Mrs. Reeves. Because I'm a girl. Mrs. Reeves studied the kids again. You know what? A lot of you don't look like the signs. Let's try this. Look at the person next to you and help them stand next to the people who look like them. Arguing and giggling, the kids shuffled and reshuffled until everyone found a place to stand. Mrs. Reeves pointed at the board. Are these pictures of what boys and girls really looked like? Yes, said Emily. No, said Sophie. Sometimes, said Jacob. I wonder if there's another way. Everyone has a right to use the bathroom, right? We should make our own bathroom signs, said Sophie. And rules, said Jacob, like if you're in the bathroom and you see a kid who doesn't look like you, you leave them alone. Or, I have to pee, so let me be, said Noah. The giggling turned to cheers. Great ideas, said Mrs. Reeves. Let's get to work. The afternoon was filled with markers and laughter, so all the kids worked on making signs for the bathroom. New bathroom signs went up. Everybody uses the bathroom, and it has a sign of a girl and a boy on it. Leave kids alone in the bathroom. Be respectful. Be kind. Jacob and Sophie stopped outside the bathroom doors. They looked and said, "Do you think it's okay?" asked Jacob. Sophie smiled. "I think it will be." And they went in because they worked it out themselves. And these are, obviously small children. But I just wanted to read that because I thought it was appropriate for this workshop. Thank you.
Thank you, Ms. Fisher. Are there any other questions right now? Ms. Giovanelli, please.
I actually have questions, but I would prefer Ms. Patrica because I think a lot of her questions might be similar to mine. So I would ask that she finish her questions. I'm very interested in her questions. Thank you.
Okay, perfect. Ms. Patrica, if that's okay?
Okay, so slide 7. Let me get to it, because sometimes I didn't write what the content was that gave me the question. I think I don't understand what the responsibility is for a school counselor, a social worker, a teacher, whatever. A student goes to one of those people. What is the student's expectation with regard to confidentiality of information shared with a counselor in a school? I did do some research on confidentiality for people under the age of 18, and it seems that the right to confidentiality is not absolute, and that the parent has the right to direct that. So I'm not clear on, how do we handle that in our schools?
I'll take that. Yeah, I know in previous we've had Lori Brooks up here, but what's up? But one of the issues, and I was trying to kind of carve this out a little bit. There are privacy issues that are related to where the parents do have access to information, and again, there's a balancing test there depending on the issue at hand. So again, to make it kind of break it down into some issues, if the information goes into a student record, the parents have access to that student record. Oftentimes what we're seeing in a school setting, and it may not be the guidance counselor, it may not be a social worker or anyone at the school, we see a lot of situations where individuals at the school observe things, or they hear things that regarding a student or a particular student, or they believe things based on what they see related to that student. And there's a difference between those two types of information. You have one set of information that is not contained in a student record. It's based on observations or maybe even a conversation with that particular student, and then other information that's contained in a student educational record. The difference being, you're correct, there is a little bit of a debate about what is accessible, what is not, and there's actually a lawsuit, I believe, pending in the state of Maryland right now regarding a similar set of facts over a school district's policies as it relates to privacy issues, and in particular, what could be disclosed and what can't. And I think that, again, what happens with this is that they try to people try to pigeonhole it into one area and then kind of apply it across the board. And there are instances where some information can be disclosed and some information cannot. But it's not absolute either way. Only with respect to records it is. Parents have access to that. There's no denying that. With respect to information shared by the student, it becomes the student's interests, which they can either agree to have disclosed or not have disclosed. Staff should also not share it amongst themselves unless it is directly related to that student's educational needs. And so the confusion comes where there are instances where it can be provided, and there are instances where it cannot. And I think that, we do our best to kind of educate our staff as to when those incidents occur and when they do not. And I know Chuck's trying to pull some information up. But to answer your question, it isn't always one way or another. And again, I can go through a myriad of hypotheticals, but it depends on what the exact factual scenario is as to whether that information can be disclosed and cannot. And I think that a lot of people hear, oh, we don't have to disclose anything, and that's not what we're saying. And most times with the plans that we're putting together with the students, we're trying to involve the parents. We don't want to not involve the parents with respect to these issues or not share information. And I think sometimes parents hear that, and that couldn't be further from the truth. I think it's for the well-being of the student. Again, we want to have all parties involved, both within the school setting and at home. And so there is a kind of universal approach to it while still respecting the rights of that individual student.
I get that. I get that we want to include all of the parties. I'm not questioning that. I'm questioning the parent's right to know here. So it's my understanding that if I seek private counseling for my child, I sit down with that counselor and we decide in the beginning of the relationship what's to be kept confidential, what's not to be kept confidential. Obviously, the younger the child, the more I'm going to be involved as a parent. As that child ages up, the discussions will continue and more will be held in confidence for the benefit of the child. Am I having those discussions with my child's school counselor as well? Are we determining up front the nature of the relationship and the nature of what is expressed on behalf of my child to the counselor that I agree to be kept confidential so that the child can have a meaningful counseling relationship going forward that's in line with my comfort and my rights as a parent? Am I making sense?
No, you are.
Is that an apt comparison to make a private counselor on the outside compared to a counselor in a public school setting?
Miss,
And,
can I
we
have
don't,
Ms. Fisher say, I think she wants to answer.
Yeah,
as
if
a-
I can
as
just
a
address that,
ex-counselor.
again, from personal experience at all levels, including high school. So if a child would come to my office and they wanted to talk, I would let them know that anything that they said, and they said, are you going to tell anybody? And I had to say, well, and this is part of the training, the ethics training for counselors, social workers, and nurses. I had to say, okay, anything you say to me is confidential, and I would explain what that meant if the child was young. However, if you are hurting yourself or someone else, or someone is hurting you, or you're in any danger, we must talk to your parents. And then in developing a relationship with the child, you get that level of trust. And my end goal was always to include the parents at some point. And so, and encourage the kids. Now, you told me this, I think you really need to talk to your mom or dad about this. And they were like, well, I'm nervous about that. Sometimes I would help with that and say, okay, you want to call your parent and invite them to come in? And many times that worked. So counselors will keep things confidential, but it is a case-by-case basis. And if there's any danger to the child or, to the psyche of the child, a concerted effort is always made. And parents do have the opportunity to meet with their school counselor, and if they're not comfortable with that, then they can say, no, I don't want my child to see the school counselor. So there is that in existence and has been for quite a while.
Thank you, Ms. Fisher. Christine, I'm sorry.
No, I was just going to highlight the cases that Mr. Williams discussed as well. They're very clear that the right not to have intimate facts about one's life disclosed without their consent is a venerable right whose constitutional significance is recognized. That was the Sterling case. And then you have the
What slide is that?
that would be probably,
7 or 8.
it's right there. It's up there right
I
now.
think it's 7 or 8.
Yeah. And then the next case as well, recognizes the right to a student's privacy. That involved a student whose pregnancy status was disclosed. But, it said you've got to weigh those. So as Ms. Fisher stated, we've got to weigh every situation on a case-by-case basis.
So the comparison of the outside private counseling relationship to the public school counseling relationship, that's not an apt comparison? A counselor in a school can keep things confidential? From me as a parent, that a counselor on the outside doesn't agree to keep confidential? Do you understand the question?
I do.
I'm not trying
and-
to be combative, I'm really trying to
No.
understand. I really am trying to understand.
And I think, unfortunately, Ms. Brooks had a scheduling conflict. She explains this quite well. And I think the role, and Chuck can elaborate too, the role of the counselor is to work with the child, as Ms. Fisher stated, and it's not to actively hide information. It's to ensure that the student is safe and then involve other parties when necessary.
This is actually the statement that Ms. Brooks provided previously, and it simply says, as schools work with the unique needs of LGBTQ+ students, it is with utmost care that staff works to balance the support and confidentiality of each student with their parents' or guardians' inherent rights to be the guiding voice in their child's life. School counselors working with children and adolescents in any setting often find it challenging to balance their obligations to keep private the information disclosed in confidence to them with others' rights to know. The American School Counselors Association states, it is the school counselor's responsibility to fully respect the right to privacy of those with whom they enter a counseling relationship and to provide an atmosphere of trust and confidence. ASCA position paper on the school counselor and confidentiality. The counseling relationship between students and their school counselor requires an atmosphere of trust and confidence. Students must trust their school counselor to be able to enter into a meaningful and honest dialogue with the school counselor. However, school counselors must also inform students that exceptions to confidentiality exist in which school counselors must inform others of information they obtain in the counseling relationship. The basic thresholds for a breach in confidentiality are set forth in law. In addition to mandatory reporting of suspected abuse, statute requires disclosure of breach of confidentiality when there exists a danger to self or danger to others, which can also be defined in a serious and foreseeable harm. Students should be informed when situations arise in which school counselors have a responsibility to disclose information obtained in counseling relationships to others to protect students, themselves, or other individuals. After the basic thresholds set forth in statute regarding required disclosure, professional ethics become the guiding principle for school counselors, social workers, school psychologists, and licensed mental health professionals as they work with students. Limits of confidentiality are explained to students in an ongoing manner. Students need to be well aware of these limits and reminded of them throughout their work with the school counselor or other school-based mental health professional. Confidentiality ensures that school counselors will not share students' disclosures with others except when the student authorizes it or when the aforementioned required threshold for disclosures are met. In addition to the trusting and confidential nature of the student counselor's relationship with students, the school counselor's relationship with students, another consideration is central to their work. That consideration is the parent or guardian's right to be the guiding voice in their children's lives. The American School Counseling Association states, school counselors recognize their primary obligation regarding confidentiality is to the student, but balance that obligation with the understanding of the family or guardian's legal and inherent rights to the guiding voice of their children, to be the guiding voice of their children's lives. For this reason, as school counselors and other school mental health professionals, we engage with students on any sensitive topic. Not only are the limits of confidentiality discussed in an ongoing manner, the involvement of the students' parents and guardians in that student situation is a significant part of those discussions. School counselors work with students to find ways to support them in sharing sensitive information with their parents and encouraging them throughout these discussions to do so. If the student has not already disclosed or shared with their parent guardian on these sensitive topics. In addition to helping students work through their thoughts and feelings on sensitive issues, the role of the school counselor is also to help students find the tools and means to talk with their parents, guardians about these topics in a supportive environment. School counselors also provide parents with resources and tools to support their child in navigating these important developmental milestones. For additional reading on this topic, there are 2 American School Counselor Association position papers that board members may find helpful to read. And she said she
Okay, so I'm much better at reading. Could you send that to me so that I can, to all of us, so that I can read it?
Hey, Ms. Patrica, I'm going to let Ms. Vaughn,
Yeah,
she had something I
Yeah, I
believe that was with.
wanted to clarify something that might help Ms. Patrica's questions. We need to look at the reality of school counselors in 2021. First of all, a school counselor, what Ms. Fisher described, to me, that's extremely accurate, except for the fact that a school counselor is not a therapist, okay? Is not typically a clinical psychologist who would deal with these things. The reality is that in today's school settings, and I'm thinking about high school now, the counselor becomes a test administrator. The counselor often is, especially I imagine with COVID absences, might become an emergency substitute. A school counselor often is on lunch duty, okay? I've heard many of my friends when I was teaching at Estero High School who are counselors, actually they're both retired now, but complain about the fact that it was really difficult to find any quality time to deal with students and these kinds of issues because they had so many administrative things that they had to do, so many things that were out of the realm of counseling. So certainly if it's an emergency situation, certainly as the counselor can fit in issues with a student that is having difficulties, and but I'm just being realistic here. We do have school psychologists, but the last that I heard on this, we don't have enough of them. We don't have enough school psychologists and counselors to deal with the myriad of mental health issues that hundreds of students in a school. So to look at a school counselor beyond someone that can provide emergency help, temporary help, and give the student other avenues to explore. You know, somebody here correct me if I'm wrong, but I just don't think a school counselor has time to deal on a weekly basis, like an hour a week, with one particular student the way a therapist or a clinical psychologist would have that time. So if anybody here, Mr. Bradley or anybody, if you have something different to say on this, please correct me.
Did anyone have any comments? Thank you, Ms. Vaughn.
We're off topic.
Yeah,
Well, I don't think that's off topic because it was brought up about the role of the school counselor. It's not off topic at all. If we're,
thank you, Ms. Vaughn.
well, no, if we're talking about this, it's not off topic. I'm sorry. It's not.
Mr. Bradley or anyone down there, did you have a comment to that? Because I'm going to ask Ms. Patrica to continue the questions and.
I don't have a specific response to it. I do think that's a great question and certainly worthy.
I was just asking if it's legitimate or not, but I thought it might clarify what Ms. Patrica's asking about.
Okay.
All
Ms.
right, so I
Patrica, will you?
appreciate that clarification. So let's say we're dealing with a counselor or a school psychologist. My child or any child approaches and brings up concerns of any nature. What I just heard you read, in my mind, there's a difference between HIPAA laws, where the parent's right to know is primary, and the parent negotiates with the psychologist or the counselor, the extent to which that confidentiality will be in place, and the extent to which the parent will give up their right to know, versus a school counseling guidance where the child's right to confidentiality is placed at a higher premium than the parent's right to know. Is that's what I heard you say? Did I interpret that incorrectly?
I wouldn't characterize it the way you said it. I wouldn't say that it's at a higher premium. I think that it's just acknowledging that there is an interest in that student's rights to that information and who that information is disclosed to. And I think the difference is, again, and to Ms. Vaughn's point as well, the topic as it relates to counselors and our psychologists, I think we're all struggling on how to answer that because the person most suited to answering that isn't here. But it becomes a topic of its own with respect to how that situation is handled, because it is a very delicate situation and it should be handled in a very delicate manner. But to your point of where that information goes, it's not that the schools are not acknowledging the rights of the parent. It's just that there is a legal right to that information for the student, and there are limited circumstances where that can exist, but it still exists.
I'm as clear.
I know.
I'm as clear as mud. I'm not comfortable. I'll tell you, as a parent, I'm not comfortable knowing that my child's school counselor or psychologist can keep things from me that my child's private counselor or psychologist cannot keep from me. That brings about a level of discomfort for me as a parent, and in terms of directing my child's education and welfare, and me being able to sort of direct these conversations. And it's not just in this area. Mr. Williams, you indicated that we could go through a bunch of hypotheticals, and I actually have a bunch of questions in here about hypotheticals so that I can really understand in a broad way what we're talking about. Is it fair to ask to go through some of that?
I mean, you can. What I would say to hypotheticals, and the reason I said that is, you can create a hypothetical, but we would have to assess a lot of information regarding a hypothetical. And you can write a hypothetical, but again, I'm going to just ask you more questions about it, and we can keep going back and forth about what the answers to those questions would be. But my point is that when these issues come, it's important that the district's legal department, as well as our school psychologists and social workers, and as well as the school site itself and district staff, work together in assessing these issues. And they're not made in a vacuum. We bring in a bunch of people to look at each of the issues because there's different perspectives as it relates to those issues. So giving me a hypothetical, I would say, give me 10 minutes each time you ask the question for me to go in the room with all of the people involved to answer that question. And I think that would be fair, as opposed to a hypothetical where we have to respond where, again, there's limited information about what the context of that hypothetical is.
And I also wanted to share something, because I know I keep hearing, the question was what counselors can keep from you within a school versus outside. If a child is going to counseling on the outside, they are entrusted with the same value as far as that privacy with the child. And I know that firsthand, because I have had some of my kids have gone through that, and they're not going to have that conversation with you, what they have been talking to them about, because that is their privacy, and that's their space to speak. Now, if there's something that, as Ms. Fisher had said, that was alarming to them, or that they felt that was going to hurt them, then they would share that. But as far as them being able to go in there and have conversation with their counselors outside, private ones, it is private to them. So I just wanted to share that with you, because
It's not my understanding of HIPAA and how HIPAA directs.
well, I'm telling you firsthand knowledge of my experience with them, just so I just wanted to share, put that out there.
And Ms. Patrica, I think it is a conversation that we can have with Lori Brooks.
Yeah.
You know, if there are parents who are not comfortable with that relationship and want to define it from the start, it would be something that we could definitely discuss with Ms. Brooks moving forward.
And maybe we could have her come in and share that with us. Ms. Gittens?
I was, good morning, I'm sorry I was late, I had a previous engagement, and thank you all for the presentation. I did listen on my way in, so excellent job of explaining. And the comment I wanted to make is, and no offense to Ms. Patrica, but, and I know she's like representing some parents' views. So my question is, are there opportunities I keep going back to community forums and open conversations, if we have those opportunities for parents to partake in those? I mean, here on this board, we hear from, one current parent, we hear from a grandparent, but the majority, the plethora of people involved are out there, and they have questions and they have concerns, and to sit in a forum to hear what you have to say, to answer their questions, would cover, a multitude of parental situations. I just think we really need to have parental involvement to understand. And I don't know if it's a big group or a smaller group, and, so that it's a little more controllable, because in a big group, people kind of, get out there and do their thing. Maybe smaller groups and by invitation or something if they want to do that. But we're not going to solve it for every parent in Lee County on this board. I just don't, we don't represent every single parent. And so I'm just saying, how can we do that? Can we, superintendent, ask for these types of group settings where parents can sit comfortably with counselors from their schools to talk about what their day is like, what they do? And the last thing I want to say about it too, being a teacher, it's not always just the counselor. I have had on many occasions students, LGBTQ students, coming into my classroom at the end of the day or early in the morning, closing the door, and me having to say, just, kids are coming in, to just go into the storage room and get yourself together for a minute, and I'll come in and talk to you. So it's not just the counselors. I agree with Ms. Vaughn. The counselors are super busy being test givers, and I don't know how old everybody else is, but when I was in school, counselors did what you're talking about. And today, they don't have the time to do that. Children gravitate to who they feel comfortable with. They might even, Ms. Patrica, have this conversation with the janitor. They may have that conversation with a coach. So we have to look at where, confidentiality, and do we take away from them the ability to talk to someone that at that moment they feel comfortable talking to? And that moment, that maintenance person or that coach or that, assistant coach might keep them off of the list of a tragedy.
Good point, Ms. Gittens. Did you want to, Ms. Giovanelli, I know that you
I'll just jump in just a little bit because what I'm not hearing, so we're policymakers, we're governance, right? So I feel like some of this is a little bit, we're overreaching a little bit because I need to know, I want the data that tells me how many students are dealing with this in Lee County. What is our numbers? I don't have any of that information. I would have loved to have been briefed by experts in this field that has gender studies and public policy brief us. I'm sorry, but I don't feel like that. The school district needs to be educating children, all children. There's no ifs, ands about it. All means all. So that's what the whole thing is about, is children. So it doesn't matter who the children are. It's their children. That's it. I mean, there's no gender issues with that. So I want to see what's the number of transgender students that we have in Lee County. That's my notes I was writing here. And how many of them, how many complaints do we have presently that we have that by not having a policy in place governing this? What is our numbers with that? Because I mean, there's a lot of issues that we could take on as in Lee County. I mean, we have homeless issues. We have kids have eating disorders. Are we gonna start categorizing and making policy on that? So I think we have to. The Constitution allows parents to have parental rights. We can never take that away. So I'm agreeing with Ms. Patrica's questions. So I mean, there's information that we weren't given. And what's the data and give me the cases on both sides of it affecting children either way. So that's where I'm going with, my thoughts are, because, and then I had a couple questions. What LGBT plus, what does the plus mean in that meaning exactly? And then there was the 12.27 policy. Mr. Hudak said that it was posted in classrooms. Where is that posted at? I've been in several classrooms. I've never seen it posted. So I was just curious about that. And then the FSAA ruling, we belong to that, and their ruling regarding sports. We just should stay in line with what they've made, their decision is on that. Let the professionals handle some of these issues that you are talking about. I think training is great for our staff and handling it, but at this point, if it's out of our realm, we don't want to be held liable for not giving proper medical treatment if something's needed. So it needs to go to the parents. So I just don't see confidential, that could be a problem at some point if we're not telling parents what's happening to their children.
Ms. Giovanelli, I think that the reason for today's workshop is we asked them to come and share with us on what we are doing here in the district. That's why they're here and not experts there. And then also, do you want them to answer all these questions? So that way, as far as where are they located in because I know you went through a whole bunch of them. Where are they located in the classroom? I know we're not doing anything medical for children. What was I was trying to write down what you were saying. Okay, so where are they posted in the classroom? And then 1.27 is what you were talking about, correct?
Yeah, he mentioned it at the beginning of his.
Okay.
Right, so they should be posted. It's up to the administrator of the building to ensure that they're generally just like a piece of paper printed they give, and generally they're just posted on a bulletin board. I know Mr. Bradley and I did an audit of this central office building that each department has it, but the administrators at each building site should be ensuring that each teacher has those posted in their classrooms. And it's not like a big bulletin board, it's just a printed piece of paper, and they're generally posted somewhere in the class.
Okay, and then you had, what was your other question? What does the plus mean? Sorry, I knew
and just to add on to what Mr. Hudak said, to finish that question, it's also posted in our student code of conduct in both editions. Right. The plus identifies all of those who do not identify as heterosexual or homosexual, bisexual, transgender, lesbian. It includes those that may identify as gender fluid, those who identify as pansexual, those who identify as something other than the other initials.
Okay, thank you.
Also, Ms. Giovanelli, just to give you, we don't have exact figures here in the district. We don't have a tool, an instrument that collects the data locally in terms of the number of our students that identify as LGBTQ+. But we do have state figures, and currently 18.2% of students in the state of Florida identify somewhere as not heterosexual. So that includes LGBTQ+, and then 1.5% of those identify as transgender, and that was as of 2019.
Okay, and then she also had, and I guess, Mr. Hudak, how many complaints regarding what, Title IX, perhaps, that we have received?
From my end, for employees, I have 0 complaints regarding Title IX at this time.
I'm sorry, I couldn't understand.
Employees, I have 0 at this time regarding Title IX.
0 for employees? Do we have any for students then?
So since the beginning of the school year, we've had about at least a dozen cases that have been closed. I have 2 active cases I'm currently working with.
Okay, thank you. And was there something else that I missed?
There was one point she made about FHSAA, and I'll let
Thank you.
Ms. Strode kind of fill that in, but I think she was trying to be very clear that we are following the state guidelines as it relates to athletics. We're not deviating. We're not going out on a whim or assumption. We're following the guidelines from the state, and we're keeping abreast of what's currently going on at the state level, including current legislation before our governing bodies.
Perfect.
So that leads me, so to be clear then, we're not deciding to make a policy on this or anything like that, right?
Correct.
Okay, that's what I think needs to be clear as well. Okay, thank you.
This is just information purposes.
Thank
Yes.
Through the chair, one last thing. To Ms. Gitten's point, there are 2 sides to this, and I think, there's a lot of focus on the parental side and the exposure and all, and what, there is exposure on the other end as well. If information, there's a reason that student's not sharing that information with their parents. And that information, and again, without going into hypotheticals, because you could create one that ends any way you want, but again, there are concerns and liability and exposure legally if information is disclosed to that parent and that parent does some harm to that student, then that's on us as well, because again, if we're saying that information is a privacy interest of that student and there's a reason, and we have to evaluate all of those things, and again, this is where it's a case-by-case analysis. If we believe there's potential harm to that student, we may have to report that. And so there are a lot of moving parts here where the result of sharing that information can have an ultimate negative impact on that student, and it's difficult. It's difficult that schools are put in these situations, and this happens in numerous instances, whether it be child custody or this issue, where the school is put in the middle of 2 different interests and having to navigate these waters. So I don't want to give the perception that these decisions are made, just on a whim, but they're made with careful thought, hence why I said that we would likely have to get a few people in the room to have this conversation depending on what issue was brought to our attention. So
Thank you. Ms. Gittens?
2 things. First thing, Mr. Bradley, the data that you gave, the 18.2 and the 1.5, is there a further breakdown of that by age or by grade level?
We could get those figures.
I would appreciate that.
Behavior survey, yes.
I'd appreciate that. Because, and maybe I'm offline with this, but I think more parents are concerned about the younger age groups. And as students get older, it's like we almost kind of feel they can make their own decisions, and that therein lies that, the rub. And kind of back to what Ms. Giovanelli was saying, I thought the purpose of us having a workshop began in October of last year when we were faced with the decision of a resolution. And I had asked several times, when are we going to, well, it was put off and said, we want to workshop it first. That's what we were told. And it kept getting put off, and I was concerned we were getting so far away from the purpose of even doing this. And in my mind, eventually, we're going to have to decide what events we will observe and we will not observe. So gathering this information should help us to do that, but June is coming. We had October and we discussed June and the different events, and we have not, as a governance team, decided anything yet. We've just kicked the can down the road. And I know it's a difficult decision and question, but as we're gathering information, we have to keep in mind, we will have to decide what we're going to do unless something is already on the books that we're doing. That was the reason for all of this.
Ms. Gittens, we as a board already approved a certain date for a resolution. So that's already, that was done, I think it was 2 months ago, maybe 3 months. And I apologize, I don't have that exact date when we did that, but it was when we listed, everything was listed together. We talked about all the items that were on there, and that was already voted for. So this is definitely information that we have been getting, so people have an understanding of what is, what we are doing as a district, what is out there as far as that we're not teaching children any of this, but that's what the main thing was for this.
And I agree with that, because that's the main thing, the calls that I get, you're teaching our children this and that. Sure. And that's the main thing when I go back to having those parent groups, to show them curriculum and tell them what we're doing and what we're not doing. And I recall now, choosing which resolutions and all of that. Can you remind me, though, did we decide either June or October?
Because I don't, of my head, I cannot recall the, Mr. Pre-Bruno?
Yes, Madam Chair, you decided that in October. Okay. You were going to celebrate it in October.
Thank you. Thank you.
LGBTQ history.
Because I know there was 2 and we decided on 1. Okay, thank you. Ms. Patrica.
Slide 13, please. I'm not clear, if you could help me understand how Grunke, is that how you say that, the case name? Grunke?
Sounds good.
That's how I'll say it. How that's even relevant here? Because the specific piece of the court quote that you gave to us arises out of a Fourth Amendment search and seizure issue. There are no LGBT issues involved in this case at all, and I'm not clear on how that even applies here.
I'll take that one. When you get into privacy rights of students, you've got multiple topics: pregnancy, search and seizure, LGBT instances like this. And I think when you're looking at the guidance, you have to look at all of the case law as it relates to it. And this Grunke case actually sets a standard for when information can be disclosed, that despite the privacy interest, right? And again, I would highlight the legitimate or compelling interest in notifying parents. And I think that bright line standard is kind of cited throughout cases following that as a means by which information can be communicated to the parents despite the privacy interest that student may have. And again, that goes back to my point that there are instances, this is not a bright line rule where the student tells something to the school and we don't have to share it. There are numerous instances where that information must be shared. And again, whenever you get a legitimate or compelling interest notifying, that could be as broad as you like to make it, or try to make it, or as narrow as you'd like to make it. So I think in a lot of instances, there are school districts that are relying on that provision for purposes of actually disclosing. Not necessarily.
So the bullet point below that recommend that if there's not a legitimate compelling interest, is that your recommendation as legal staff? Is that a recommendation that came out of that case? I'm not clear on where that recommendation came from, because I read the quote from that case much differently than the way you have interpreted it. To me, this quote means parents' right. The parents' right is the most important consideration, and information can be withheld from the parent only if there's a compelling interest by the school.
And that's correct. And no, and you're correct in that assessment. But again, that is an analysis that is made when we get these types of issues. That, you know, whether or not there is a compelling reason. For example, the parent has threatened to kill the student. You know, there could be a multitude of reasons why there would be an interest in not sharing. And again, a lot of times that will have to do with usually a health and safety or welfare of someone involved in the particular situation.
So then we err on the side of sharing information with parents. That's what I'm getting here. I mean, I get if the child comes to you and says, my parent's going to kill me, obviously you're not going to share that with the parent. You're going to go to the appropriate authorities and handle it that way. But in just a regular conversation where the child's safety and well-being is not at issue, the parent's right to know is supreme, and you can only keep that information from the parent if there's a compelling reason to do so. Is that?
I mean, no, I would agree that is the way that a lot of districts are interpreting that position.
Is that the way we're interpreting that?
I think we're interpreting it to honoring the right of the parent to know while taking into consideration the rights of the student. I think, I want to say for the most part, information is being shared with parents. And I think that we try to get there regardless of where the student is on the issue. So because these are and I think we said it, these are very sensitive topics, and these students are trying to navigate them with assistance from, you know, in some cases, a school counselor. And so we absolutely want to involve the parents to the extent that we can, because it's important that these issues are addressed not only at the school but at home. I mean, we can have our own discussions and then send the student home and they're left to fend for themselves. And I don't think we're trying to put any student in that situation. And I think we also all understand how hurtful that must be for a parent to find out that their child doesn't want to share information with them. I mean, I can only imagine. And so, you know, again, to your point, yes, we are sharing information absent something that would suggest that it would be inappropriate to do so.
Okay.
And I think for that case I told you about in Maryland, I think that's what where that one's headed. So.
Okay. Can I keep going? Yes. Go ahead. So slide 15. I think I asked this question before. Do we have to open GSAs to pre-K-8 students because algebra is offered in a pre-K-8 educational environment?
That is what the Carver case found, and that is the 11th Circuit. So
that was a middle school, though. That wasn't a pre-K-8.
It wasn't a pre-K-8. I think that would have to be specifically analyzed based on the school. Is it open to all K-8 students, or is it just the upper grade students? I think you'd need to carve out some parameters for that.
And then when it comes to, this is sort of jumping ahead a little bit, high school, just in general, when our students graduate with the regalia and the robes and the ropes and all of the stuff that they put around their necks, do we recognize anything other than academic achievement in that regalia? Like, do we recognize athletic achievement? Do we recognize GSA involvement? Do we recognize student government? Do we recognize anything that's not academic?
I have the answer to that, if you don't mind. I was senior class sponsor for a couple of years, and there are certain academic like chords and all that. And I can recall, I know he's coming up because I can recall there was a time that different clubs wanted to be recognized, and it had to be a vote and a decision as to which chords would be used. And most of the time it was academic, though. So,
Dr. Spiro?
Thank you, Ms. Gittens. It is a school-by-school decision, so the schools determine how students will be recognized through the chords that you're specifically referring to.
Okay, so if a school decided to, they could recognize every football player with a with football beads around their neck or something?
Schools would determine that. Usually they work through their leadership team inside of their building, and there's very clear criteria on what type of cords are recognized at graduations. Now, I will stereotype now and say generally across the board, most of it are academically focused. Most of them are honor societies. But I cannot stand here and look at you and say there aren't other groups that are recognized by wearing a cord as well.
And the reason why I ask is because a parent came to me upset that her daughter couldn't wear rainbow cords at graduation. And I don't recall being at a graduation where anything other than academic achievements were recognized visually at a graduation. But you're saying that a GSA club could go to the principal and have that conversation and perhaps graduate with rainbow cords provided by the school.
That's a school-by-school decision, yes, and they would make that determination by their school.
Okay, thank you. You're welcome. Slide 17. I think that what makes me the most comfortable with this policy, and this policy was enacted before I got on that board, is the use of the word consistent before gender identity. I think that there's significant concern on my own behalf about gender fluidity and bathroom and locker room use based on a child's gender fluid identity. But the consistent gender identity brings me a greater sense of comfort, knowing that that we're talking about gender dysphoria, which has been recognized, from what I understand, by the American Pediatrics Association, whereas gender fluidity has not. So can I be confident that any decisions we're making regarding accommodations are being made based on consistent gender identity and not gender fluidity?
Absolutely.
Yes,
Okay.
and again, we use a standard of consistent, persistent, and insistent. So we're looking for all three.
All right, and then I see Mr. LaRosa in the back. Are we actively training our coaches and our athletic directors on this so that there are no missteps if a child comes to a coach or goes to a coach and has this conversation?
Yes, every year at the beginning of the school year, we have meetings with all of our coaches. This year we had to do it via Zoom. But in our presentations to them, all these types of items are discussed with them.
Thank you.
And we are following the guidelines of the FHSA in regards to all of this.
Yep, that makes sense.
Go ahead.
Okay, slide 20. How do the rainbow signs meet any of the requirements or goals stated on 20? I have to tell you that the rainbow in particular bothers me. It is the most recognized political symbol in the world. And as an apolitical body and as a public school system that's not supposed to be political, I think that putting a political symbol in our schools is inappropriate. And so I'm not clear on how the rainbow portion of the sign accomplishes any of the goals on 20. Because I believe those goals can be completed or met without using a political symbol to advertise what we're doing.
Does anybody have an answer to that? That's just a statement.
I think there could be debate on whether or not it's a political symbol. I know Mr. Bradley has some information about the history of how that symbol came to be. And I know our previous stickers also utilized something that has been associated, I think it was the inverted triangle with a rainbow. So I'm going to defer to him. I think the legal piece, though, is debatable.
So without venturing too far into the comic, because that is somewhat inflammatory, the symbol of the rainbow was created specifically to remove the disparaging symbol that was used for gay people in particular, which was an inverted paint triangle, which has its origin in Nazi Germany. And it was used to identify homosexual prisoners in the concentration camps. It was used derogatorily for many decades to identify and disparage homosexuals. During the civil rights movement after Stonewall, the pride flag was created as a symbol to provide hope for those that don't identify or were marginalized at that time. It has been politicized. It was never a political symbol. It was not of or pertaining to a political party. As a matter of fact, it represents people from a broad spectrum of political backgrounds, including extreme conservatives and extreme liberals and everything in between. So it is a symbol that is recognized in terms of our students who we're trying to message to that they matter, they're included, we care about them, and there are people here that will help them regardless of their gender identity or sexual orientation.
Thank you. And it's a symbol of pride.
Yeah, I was just going to add that it's a symbol of pride, much like the red, black, and green flag, is a symbol of pride for African Americans during Black History Month. I put that on my door, so if that's political, I apologize. But I don't think, again, to Ms. Schroed's point, I think that's debatable, and I think it depends on what side of the issue you fall on. But to my knowledge, it's a source of pride, and for those reasons, I don't think it necessarily kind of meets the context of what we were previously discussing. So.
Okay, well, I disagree. I think it's political, and I think that where do we stop? Do I start to hang pro-life symbols in front of my name because I'm strongly pro-life and I'm raising my children that way? And if I'm a teacher, can I hang the pro-life symbol in my classroom in order to promote that I think that there's a way to accomplish this, to let students know that they're safe and that whatever issue they're having that's causing them difficulty, or they're feeling the target of bullying, or they're feeling the target of harassment, whether it be sexual orientation, sexual identity, or it's the fact that they have red hair and people make fun of them for their red hair, there's a way for us to reach our students and let them know that kind of behavior is not tolerated in our schools, regardless of the issue. And I think the other thing that's important to understand is my perspective as a parent. The issues that we're talking about here are incredibly intimate and incredibly private. And the level of discomfort I have as an adult walking through the school district of Lee County with these signs hanging throughout the district, to me that's an invitation to discuss issues that are intimate and private and should be discussed at home. And the environment that it creates for me is one of extreme discomfort. And I know that there are children that share that sense as well. They go to school without an expectation that issues surrounding sexuality, sexual identity have to be discussed, yet they're being encouraged to discuss it with the presence of these signs. Am I making sense? Yeah. Like that's, when we talk about all kids, we really do talk about all kids, and that's a perspective that I think is not taken into consideration in this.
You're making sense. Obviously, there's a lot to unpack there. There's a lot of different issues that you brought up as it relates to, clearly there's freedom of expression issues involved and freedom of speech issues involved in some of that context in terms of what is permissible and what is not. And again, there are legal analysis with respect to various different things in that regard. As far as, the discussions that come up as a result, I think depending on who you talk to, they'll say those conversations come up regardless of whether there's a sticker on the wall. So, to kind of pinpoint that as the basis for it, without knowing, it could be the reason. I don't know. But I think we have to, as a local governmental agency, balance, First Amendment freedom of expression rights against the impact that it has on the educational setting. I think when you talk to most people, they'll tell you that, I know staff will say that they've gotten a very positive response to those stickers, both from students and staff. So it goes both ways, and I'm not disregarding your perspective. I think it's important that we have these types of conversations so that we understand all of the perspectives that are out there, because you're a parent, we have other parents that share similar views, and we have to understand all perspectives as we as a district, navigate these waters in terms of implementing processes and identifying issues that are important both to our parents and to our students. So.
Is it age appropriate to have that in elementaries?
Order. How long is this?
May I please?
Well, she was asking questions because Ms. Giovanelli asked that she continue. So,
Okay,
Ms.
but are
Vaughn, can
we
you
going
please?
by
Ms.
time?
Vaughn,
Are we
do you
going
have
by
a question,
time?
please? We're good. Do you have a question, please?
All right, fine.
It's your turn. Do you have a question?
I had my hand raised.
No, I know you did, but I saw Ms. Vaughn had her hand up first, so that's why I had called on her.
Well, we've been on this one path of Ms. Patrica's opinion, and honestly, I would like to see what the rest of the board
And that's what I'm,
thinks
thank you.
about it. And I was also asking if we're going by time for
Yes, I'm
each
good.
individual.
Yes. Ms. Gittens.
Okay, well, two things. First of all, a procedural issue. I believe in Robert's Rules of Order, when someone does call for point of order, it is imperative that we do stop and recognize that and find out what their issue is. And Mr. Pre-Bruno, would you please address the fact that when a board member says point of order, because I know I have several times said that and been ignored. And I think we are breaking Robert's Rules of Order, and then I have a further question. Could you please address that?
So when a point of order is made, the chair needs to stop and make a ruling on the point of order, allow the person to explain their position, and then make a ruling on it, and you can move forward from that point.
Thank you.
And
Which I
thank you for
stopped the
having that.
conversation and asked Ms. Vaughn to speak. So please, Ms. Gittens.
Okay. And kind of in the same vein, I go back to asking about presenting this information to all parents. I feel that we're being and allowing so much time for one person to speak. It's been almost an hour and I got here late. So I think we're overstepping our own rules, and it is coming across with the ayes and the ayes and the me's and the ayes that it's not representative of all of our constituents. So I am asking that if Ms. Patrica has many more personal concerns and questions, that she get her answers offline so that we can make this at least seem like it's two-sided. If you're watching this, it seems like it's one-sided, and I don't think that that's fair to the rest of the constituents in Lee County.
And that was per Ms. Giovanelli had requested that she continue asking the questions. Ms. Fisher, do you have something that you wanted to share?
Not right now.
Okay, and Ms. Giovanelli?
Well, and I just was going to just back you up. I did ask Ms. Patrica, because I am interested in what she has to say, because I'm agreeing with most of it. So I'm sorry, and I think it's something that the community needs to hear. And I'm sorry, I'm not talking to my mic. So I think it's valid. But I have to go back to my question, because I asked about the number of transgender students, and you're telling me there's 20% in Lee County? Because that was the question.
State.
Not state.
That was state.
State.
State do not
But-
identify as strictly heterosexual.
So, okay, that's a different question though.
1.5% identify as transgender.
1.5% in the state.
State.
Correct.
Thank you. So so it's minimal even in Lee County. Right? So, we need to think about that. The data, it's all about the data, right? Thank you.
Thank you. Could you, Ms. Patrica, could you just round it up?
We've got 3 hours set aside.
Exactly, I meant to say that too. Thank you.
I know we're on time, so.
Yeah, my next question is slide 20.
Excuse me, Madam Chair. The only thing that I would recommend to the chair is that every board member has an opportunity to speak and provide their opinion, and one board member cannot, basically monopolize the conversation. So I would advise the chair, if there are any other board members, that they be allowed to speak, and if there are none, then you can go back to Ms. Patrica.
Thank you, and that's exactly what I'm doing. I'm making sure that everybody has an opportunity to speak, and then I go back to Ms. Patrica.
Thank you. Am I good? So slide 24, I remember seeing in a report that we had to send up to the state, and I can't remember the name of the report, but I know you're going to remember it. It was about the training for our equity coordinators, I believe, in the schools, and it said something about if a student has not outed themselves to the parents, then we will keep that information confidential. And I was just looking for some explanation on that, what that meant. I try not to draw conclusions based on, you know, a couple words on a slide, because I know that was part of a larger training. So what are we training our school personnel with regard to that?
It follows along with everything we've said here today, which we do train our people that they require the consent. They require the consent of the student to share that private information. So they are prohibited from sharing that information without the student's knowledge and consent.
I think what was notably absent from that previous report was just the exceptions of when we do, right? So I think that there was the takeaway I got from that when there was responses was that they never share this information. And I think that's what we're at least trying to clarify here today, that there are exceptions and notable instances wherein that information would be shared. It just wasn't spelled out, and I think in that presentation slide.
Next question.
Slide 26. Never mind. That one's, we've already gone over. Slide 29. That's more of an opinion, so I'll get to that at the end. Slide 30. Is the gender spectrum form currently in use?
It is one tool that is provided to our schools. It is not officially adopted, but it is one that is available. If a licensed practitioner in our district has others that they want to use, they're certainly welcome to.
So we use that without parental consent?
It includes working with the student and the parent.
I understand that, but when I read it, I didn't see any place on there for a parental signature, either on the gender spectrum one or on the school district of Lee County one. So a child, a student, could approach a school employee and engage in this process and change their gender identity from an outward perspective, the way, you know, the pronouns that are used, the name that's used, without parental consent.
I'm going to defer to our attorneys on that, but primarily if a student comes and they exercise their constitutional right to freedom of expression, we will recognize them.
But that's not on their legal paperwork.
That is not other legal paperwork.
So this
no.
wouldn't be part of the student's record?
Correct.
So this is something we would keep from parents?
We're not keeping anything from parents. It is simply a process of collecting information, working through with the student. It's a counselor tool.
And this might be ignorance, this might be a lack of understanding. My understanding is that gender dysphoria is a consistent gender identity issue, and typically it's directed by the parent and the child. All of the case law I've read, the parent has been involved with the child and on behalf of the child as they pursue legal remedies. I don't understand how this fits into that. I don't understand how we can do this without parental consent. I read these and I was like, oh my gosh, why is there no line for my signature?
So I can sort of address that. You know, there is a section for parent-guardian involvement. It gauges if the parent is aware of the issues, and then how are we going to account for that and plan for that and get to the point where they are sharing it. In my legal opinion, this would be a student record that a parent could request. If we feel that the student is in danger after the parent requested this information, then we would obviously take actions to protect the student. But yes, this would be a student record. It has the student's name on it. It was created in school. So that would be my legal take on it.
And let me,
It is a student record.
yeah, and let me draw the distinction too. There's a difference between a student record and information you would be disclosing to the parent. So the parent could make a request for this information, but you're not going to go out and say, hey, by the way, here's a document that, you know, your student didn't tell you about. The other thing with respect to lawsuits where they've been filed on behalf of the students, typically, the student, if they're a minor, would require the parental involvement in order to file a lawsuit. So they're under 18, they wouldn't be able to do it without the parent or guardian as the actual plaintiff. So it's usually the parent on behalf of the minor child.
And then, Ms. Patrica, you were speaking of 29, that's part of our code of conduct that went through EDAC and multiple conversations before that was put in and voted on. So that is part of our code of conduct, number 29.
Okay, I don't have, sorry.
Ms. Gittens?
My question for Ms. Patrica is, are we trying to identify what our policies are and what we do daily, or are we questioning Title IX, OCR, the overarching types of things? That's what I'm asking you.
Madam Chair, I will just remind board members to make sure they go through the chair and not through personal questions.
Thank you. And I believe...
May I ask that question to Ms. Patrica, please? Ms. Jordan.
Ms. Patrica?
I'm trying to gain a general understanding of what it is the school district does at each grade level or at each level of education. I'm trying to figure out what our legal liability is with what we're doing versus what we're not doing. And I'm trying to address the concerns that have been brought to me by many people in the community surrounding this issue.
Thank you. Are there any other questions regarding this information that we have been given today? Ms. Giovanelli?
And I'm going to back Ms. Patrica on that. I mean, I think this is information that's very knowledgeable for parents because people have these questions, and this is the time to do it. This is what 3 hours is set for. So I would like for her to continue. Thank you.
Thank you. Ms. Vaughn, please.
Earlier, when I called point of order, I also was asking the question of, since this is a workshop, a discussion, and we should exchange everybody's ideas, not just one or two people. Going back to the rainbow decal sticker, I'd like to call just for either a consensus or hear in a few words which board members are opposed to having the rainbow sticker safe place in our classrooms, and which ones are good with it.
Okay, Mr. Bruno, is that something that we need to do because it's already there? I mean, this is something that we have in our schools?
I think the board member is asking for clarification by her board members in terms of their position on this particular symbol. And I don't think it's inappropriate for her to ask that question. If the board is inclined to answer, it's up to the board members.
Well, if you all would like to answer, if you are for this, please.
Continuation, yeah.
Oh, Ms. Morgan?
Yeah, I'm just going to comment. I have no problem with the revised version because the political identification was taken out of it. So, but my comment generally is I haven't commented because I'm absolutely enjoying this conversation. I came to learn about this issue, and I came to learn about the background of the legal background of our policies and how it's being implemented. So I don't want anybody to think because I'm not asking questions that I'm not interested or I don't have questions. People who are far more intimately involved with this as a parent, as a family, or have been involved as teachers are frankly, asking questions that I wouldn't have asked. So I just want to be absolutely clear that I think this presentation has been very helpful, and I think the questions being asked have been clarifying and supportive of the whole workshop idea. So those are my comments.
No, thank you. And I am trying to make sure that everybody does have the opportunity to speak if they have something to say. And if we could get back to what Ms. Vaughn had asked, as far as the rainbow, is everyone okay with the continuing of this, or they have no issues with it?
And obviously,
please put your hand.
I am, and I don't see that it's a political symbol, especially with the branding from our school district.
You are for that,
I'm for keeping it, and I really like I don't see it as political, and especially because now we have the school district branding on it.
Thank you. Ms. Gittens?
Mr. Pre-Bruno, is it within our purview to make the decision whether it stays or goes?
She's just...
No, I understand what she's asking.
Okay, Ms. Gittens, but I know, I'm just trying to get this, what Ms. Bowen has asked of us.
I just wanted clarification, but that's okay. I am fine with it, and you may go on.
Thank you. And I think you did clarify that, but she had the right to ask that question. I am perfectly fine with that. I do not see any political side to that as well. Ms. Fisher?
Yes, and I like it because it says that this space is diverse, inclusive, accepting, and welcoming, and that it applies to all students, genders included, along with abilities, cultures, and backgrounds. So, and I don't see it as a political statement. And I think we all agreed on this when it was presented to us months back.
That is correct. Ms. Patrica?
I think we know how I feel about it. It makes me feel very uncomfortable. I think it's age inappropriate for elementary school students. And I also think the words safe space have political connotations today. I mean, the world is not a safe space. And so are we preparing students for the reality of the world, which is difficult? Things happen sometimes, and we need to figure out how to deal with those difficult things. I believe that there's a way to be inclusive of all students without using what I consider to be a political symbol that carves out a niche for specific students.
Ms. Giovanelli?
I just want to read what the colors stand for, because I did a little Googling. It says here that the design was by a drag queen named Baker, and he saw the rainbow as a national flag from the sky, so he adopted 8 colors for the stripes, each color with its own meaning: hot pink for sex, red for life, orange for healing, yellow for sunlight, green for nature, turquoise for art, indigo for harmony, and violet for spirit. I think that unicorns and rainbows are wonderful. Thank you.
Thank you. Okay, are there any other questions regarding the presentation? Anybody on this side? Ms. Fisher?
Yeah, I just want to say thank you for the presentation, and I feel like it cemented the fact that what we are doing here is working to be sure that all of our groups are included, and specifically naming at this point the LGBTQ plus population, which admittedly is small, but represents a group that has been bullied. And I had the opportunity to work in Tallahassee and Washington when we had the Jeffrey Johnston Stand Up for All Students Act passed. And I recall that some members of that group were with us, students and staff alike, and community members. So I think that what we want to do is ensure that the suicide rate and the rate of self-harm and isolation that this small group feels is diminished by including that group along with every other group: Black people, Asian people, handicapped people, all of those people who we need to take some special care to respect and include. Thank you.
Thank you. Ms. Gittens?
Yeah, I just, for the record, wanted to say I was not against this workshop or any of the questions or comments. I was just wanting to voice that all sides of the story were asked, as well as, one particular view. That was why I stated what I did, and thank you. And thank you all for the presentation.
Thank you. And again, I will say, everyone has had an opportunity this morning to ask any questions regarding these issues in the presentation, if they chose to do so. So to make sure that we had all sides to, or just so that everybody did have that opportunity. And Ms. Dupree Bruno?
Thank you, Madam Chair. I would also encourage board members to review Board Policy 1.27 on your own, the non-discrimination policy, as well as Board Policy 4.14, which is the bullying and harassment policies. I think it would be a good idea for all board members just to review that and refamiliarize yourself with the language within those policies.
Thank you. Ms. Gittens?
Yes. I had suggested earlier about having some type of community or parent involvement regarding this topic, and I am asking the superintendent what is the possibility of doing that rather than just my suggestion going off into oblivion. I would really like to see or maybe hear from the panel how they feel about doing something like that, or the feasibility of it.
And of course, we could bring that also, we'll hear from them, and then we will also bring that to our workshop so that we could have a conversation on that.
But isn't that what this workshop's about?
Not, today is not. Today is for this. As far as doing extra stuff, that will come to the workshop when we have a workshop that is just geared for board members to speak on. Mr. Pre-Bruno?
No, this is.
I was just going to.
Sorry, Mr. Pre-Bruno?
I was just going to add to what Ms. Jordan was saying. The board has decided that when there is something that they would like to discuss or get further information or have planning, that they have a special workshop that is for them, so you can have a discussion on it and then form a consensus as to whether or not you want to direct the superintendent to move forward with any particular topic.
Okay, and this is the workshop.
Go ahead, please.
This is the workshop on LGBTQ. So you are saying that we have to schedule another workshop on LGBTQ to ask for a consensus, to ask the superintendent if we can look into having parental meetings.
No, ma'am, that's not what I'm saying. I'm saying that the board in the past has made a decision that any topics that it would like to move forward for further discussion, you do need to have board consensus, and you have a special time that is scheduled for that every month, and you have your list of priorities. So this will be added to the list of priorities for the board to discuss to figure out whether or not it does want to move forward with that and direct the superintendent to have that discussion in that workshop via consensus.
And I'm sorry, but I totally disagree with that. We are in the workshop that was scheduled to discuss this topic. So what I would be requesting is some type of a consensus from the board in this workshop with this topic, that we ask the superintendent to get with staff to look into possibly having some parental workshops. That's all I'm simply asking.
Thank you. Ms. Morgan? You
Yeah,
had your hand up,
so
please.
Ms. Brooks isn't here, and I think she's the one who really should be talking about how it is that we communicate with parents, the most effective ways to provide parents with information about policy and process in the district. And then, frankly, maybe that would be an opportunity to hear from her generally about how parents are informed as part of just the broader community about things, whether it's in a SAC or whatever. So I would welcome the opportunity to hear how exceptional student education provides parents, the community, with information about the services that we provide and this topic in general. So that would be my response.
Thank you, Ms. Morgan. Ms. Gittens?
Well, wouldn't that be within the superintendent's purview to decide whether how he would handle that, to have Ms. Brooks come in or whatever? I just don't think, this is a very timely topic. And especially after today, it's going to be very much discussed in the community and still is discussed very much in the community. And I cringe to think that we put it on a list and 3-4 months down the road, we're talking about how we're going to get this information to the community that did not watch this or did not participate in this. I have a concern over that. There are students at stake at the end of all of this. So.
Thank you, Ms. Gittens. I'm going to ask Ms. Fisher, and then I'm going to ask Dr. Atkins to speak.
Yes, so this is recorded, correct? And people can access it on YouTube. I think a lot of interested people are tuning in today, and there will be further discussion. I know that Mr. Eady and Crystal do a lot of public appearances and training, not only in our own local area, but around the state. And Mr. Bradley, there's so much professional development. Many of our teachers are parents. And I think that the parent involvement thing is probably the primary challenge that we have had over many years, getting parents to come to forums. Because the parents who usually come are the parents who have the time and the wherewithal, and they're already interested and they're already informed, and they do come. But to reach the broad population, I think that we can take advantage of our social media, our website, and that, I think, is the way we can communicate best with people now, and invite people who have specific questions to contact us and contact our very professional team who are informed. So I like that suggestion, and I think that we need to look at the ways that we can implement that without necessarily identifying a location and then, inviting people to come physically, because I know that in this day and age, that is another part of the challenge. But again, I think that we have a lot of information out there. The non-discrimination policy and the information about best practices are in the code of conduct, are on the website, and why can't we make an additional effort to post it out on our social media, Facebooks, et cetera, so that people get answers to their questions, and include with that the invitation, please, for more information, contact us. Thank you.
Good point, Ms. Fisher. Dr. Atkins, did you have any comments on this matter?
My first comment would be, prior to going out and doing any type of forums, it's something I really would want to discuss with staff. Sometimes we put these together and we get out there and we don't have a lot of participation, and there's a pretty heavy workload already. If this is something that the board would like to see, of course we will do that. Ms. Brooks is not able to be here today. They're involved in training, and which is why she isn't here, and I didn't feel it necessary to pull her out for this particular workshop, because it did deal with the legal issues and best practices surrounding what we're doing around this issue, so you have the folks here. But before I respond anymore, she's certainly somebody I'd want to just check in on, so we know how we are communicating. I do say that I do believe our school principals and counselors and staff do handle these matters very well every single day. Our kids are pretty resilient, and I think they probably a lot more comfortable with these issues than a lot of us. Anyway, that's all my comments at this time. Thank you.
Thank you. Ms. Gittens?
Yes, I wasn't referring to necessarily just a typical, put out a flyer and on, social media and have people come. I understand the issues in getting people to come, but I also understand still we are a majority minority district, and the digital divide still remains. And there are not going to be a plethora of people that sit down and watch this video. I just don't see that they're going to do that. Look at the numbers. So I was not saying just put something out on social media. This is a topic that is so important to the students involved and all of our students, that just like getting academics out there, we need to look at a way to communicate with the people that are potentially involved in this. We want, just being very candid, and you guys can correct me if I'm wrong, but a lot, with us being a majority minority district, the cultures of our majority minorities are very opposed to this conversation just because of the culture, which puts a lot of pressure on our students, on 60% of our students. And maybe it's a small number involved, but it puts a lot of pressure on them. And with the mental things that are going on because of COVID and students going through all that and this added, I just think, folks, it's an important topic that we have to find some way besides, training in the district or whatever. I know of a group right now that I could get you 20 people together tomorrow that would like to discuss it, that need to be educated on not just one angle of it, but to see clearly this is what it's about. People are grabbing at chunks of this topic and not seeing the whole picture, which is why I was saying even having smaller groups where you can actually sit there and eyeball to eyeball and explain what is going on. Look at the suicide rate. That's all I have to say, and I'm done. Thank you.
Thank you. And we will have that on the list as well, so it will come back up during our workshop. Ms. Patrica?
Yeah, I just wanted to say in conclusion, thank you. I really hope that it didn't come across as combative. That wasn't the intention. The intention really was to gather as much information as possible. I don't feel comfortable as a parent or as a board member that we're protected on all sides. I don't know that there is a way to be protected on all sides. And I also don't feel comfortable that the district is putting my rights as a parent to have free access to my child's information as the premium. So I think that, further conversations, perhaps with Lori Brooks will help me get there. I do appreciate you being here, and I do appreciate the work that you put into this and the work that you put into our kids every single day. I'm just still left a little confused and a little uncomfortable. So thank you.
Okay. Did you have anything else to share? I just want to say thank you very much for sharing all this information. I think it's really good, and thank you, Ms. Fisher, for stating that it is recorded and that people are welcome to go on there and watch and listen and learn as well as we have. And then, of course, if they do have questions, they can always contact, the board. We can get further information if need be. But I truly want to say thank you very much for being here and supporting our students, our staff, and making sure that we are all learning what we don't know. So if there is, I'm sorry, Ms. Giovanelli?
So I just want to piggyback off that. Thank you very much for the presentation. I think it's important, a topic to talk about, because that's part of moving forward, is always talking about it. The bottom line is all children need to be safe, and we want to make sure that they're safe, because then they're learning, and we're here to educate children. So I think that to make that safe environment, we have to make sure that all children feel safe. And so I just want to reiterate that. So thank you for what you do. And, as long as all children are safe and we're doing it within the law of our Constitution, I think we'll be okay. Thank you.
Thank you. And thank you very much. Appreciate you being here today.
Thank you.
Next is going to be good of the order, but before we start that, I'm going to ask if we could take a break for a 10-minute break, because I have two items that will be brought up for good of the order. And I have a special attorney who will be helping us out for this afternoon. So if we could all meet back here at 11:35, that would be great. Thank you.
Some information as to how this is going to go?
Good afternoon. We are back from our 10-minute break, and we are moving on to the good of the order. At this time, I would like to say that Mr. Bruno will be stepping down, and I have for these two good of the orders, and I will have Mr. John Quick will be sitting in as the attorney for us regarding these two matters. Also, to facilitate this part of the meeting, I will be doing a maximum, with Robert's Rules of Order, I'll be doing a maximum of 5 minutes each, and we will have, if we need to go into a second round, we will. And this is not a debate, this will be a conversation. So, the first thing for good of the order is we have received 2 complaints. The first one is the Lighthouse complaint. We've all had an opportunity to review that with our attorney, Mr. Bruno. If you had the opportunity, it was there for us to look at. We are, in having this conversation, we will be speaking about issues. We will please refrain from using names that are listed on any of these. And we are here to have a conversation on how to proceed with the new information. Is there a motion on how that we're going to handle this, if anything? So with that, let me take that motion back. We need to have a conversation on the new information that we just received from Lighthouse. Is there anyone who would like to start the conversation? Is there anyone who, we need to know how we want to proceed with this issue. We had spoken about this.
Could you just clarify the new information?
I don't either.
The Lighthouse complaint.
The information as of, could you give us a date, not just new information? I haven't gotten anything.
I haven't either.
In the past couple days.
We had a conversation regarding the 219 issue.
Okay.
Okay. We spoke about that at one of our meetings prior. Since then, we have received from Lighthouse a new complaint. And that complaint was sent to our attorney, our board attorney, which had that in her office for anyone to go and read if they chose to do so. And I've sent that out to you as well. The board attorney sent that out, so it was sent out numerous times, so you all would have an opportunity to go and read it if you wish to do so. Based on the information that was received from Lighthouse, we need to have a conversation about that. So what is it that we, as a board, are looking, if anything, to do with that complaint? Ms. Vaughn.
Okay, first of all, I just wanted clarification, because when you said new complaint, I thought perhaps there was something that had come in that I wasn't privy to. That's why I asked you to clarify that. Secondly, because of conflict of interest, I want to say that I am not going to participate in the discussion of anything related solely to Lighthouse. I'm not going to participate in a consensus, and if it comes up to any kind of a vote, I will also abstain from that. So I'll be recusing myself from discussion on this one topic, and
thank you.
Not participating in any consensus or votes.
And you have the right to do so, or to participate if you chose to do so as well.
Right.
So
But I just want
that
to
be out there.
announce the reason that you will hear me not say anything specifically on this one Lighthouse issue is because it's a conflict of interest for me. I'm recusing myself, and I will be abstaining from any either consensus or possible votes on an action meeting.
Thank you. Ms. Gittens.
So in that light, may I ask and hello, Mr. Quick, thank you for being with us today. How, if there is a consensus vote, which I'll talk about that later, but if there is a consensus vote, how is that going to be affected as far as a consensus?
Hi, and thank you for having me back again.
Thank you.
I would say there's two steps. One is the board needs to determine whether or not they would like to investigate this under your policies. At least I'm speaking with regard to what's being commonly referred to as the lighthouse complaint. The language in there is not mandatory, but the board in its inherent power has the authority to do it. And if it does investigate, then if the board does choose to investigate, it would need to be handled by an external investigator because the district does not have, according to your policies, the district does not have the authority to investigate, and that's under policy 5.311 sub 6. So those, I guess, would be the two steps. That the first step, decide whether it wants to. Second step, then it would need to refer it to an external investigator.
Okay, thank you. And I'm just, for the sake of policy 5.311, regarding to this particular one, I'm just going to read that really quick. External investigators shall be used only when conflict of interest exists or upon referral by the superintendent. External investigators shall possess appropriate credentials and shall be selected based upon knowledge of the subject to the investigation. And then A, which Mr. Quick had referred to, only external investigators may be utilized for allegations against direct school board employees, to include superintendent, school board attorney, or internal auditors. Only a majority of the school board may initiate an external investigation on superintendent, school board attorney, or internal auditor. Also on B, it states that federal, state, and local government agencies, excluding district staff, have the authority to investigate a school board member, which allows us as a school board, we could decide what we would like to do and have that investigation.
Can you please read that last part again?
Yes, the federal, state, and local government agencies, excluding the district, have the authority to investigate a school board member. So, Ms. Patrica.
First of all, Ms. Jordan, thank you for having Attorney Quick here. I was really concerned about, first of all, I felt like you were probably a woman on an island for quite some time, wondering where to go for legal advice. I'm very grateful that Attorney Quick is here, because I would not have felt comfortable having this conversation without legal advice. So thank you for that. My position hasn't changed. I would like a broad-based investigation, not just based on the complaint that came in, but broad-based to include the entire leadership team on this issue.
Okay, and if I may, what I would like to ask too, if we were to decide to do this, and I have been up at I haven't slept for like a couple days on this one, but on just today in itself. But what I put on here with the lighthouse, I would be asking for a broad scope, as possibly starting with the 219 text, who knew about it before the text was sent out, what is the involvement, and who are the law enforcement that are involved, who shared the text, if any retaliation, if any, and the claims attached to this. All information related to this matter, everything, including witness tampering. So it would be very broad what I would be asking for and looking for, so we have the whole scope. Ms. Morgan.
Yeah, I would like to make a motion to that effect, so that, and then if there's a second, we can have a discussion about it.
Thank you. Do I have a second?
I'll second it.
Thank you, Ms.
This is a workshop, so obviously.
Oh, that's right, we don't do that. It's a workshop. Okay, I apologize.
All right, well, then I would like to make that the topic of a conversation amongst this board for one round of 5 minutes.
Thank you.
Is that possible?
Absolutely, yes.
Okay, thank you.
All right, so may I start with you, Ms. Morgan?
Yeah, and I agree that that's what we should be doing. That's why I've put it out there. I think we need a broad scope investigation beginning 2/19 into conduct of this board.
Okay. Ms. Gittens?
Well, my question is, yet again, we had consensus, we decided, and now you're saying that because something else has come in there that we have to just abandon the consensus that we had before and the discussion not to have outside investigation. My other thought on this is, and that I find a bit skeptical, the other thing, when you read the statute, and we have been through this, it seems like each year we have an anniversary of going through investigating one of us. And each time we do, we come back to the fact that, just like with the watermarking, that only the governor and the attorney general should be investigating board members. And I thought that that was pretty clear, and here we are again doing the same thing. We continue to go over the same stuff about investigating each other, and each time we say we don't want to investigate each other, and each time we state the statute that says only the governor and the attorney general. So my stance is going to be that if there is an appetite to do this investigation and I am outvoted, then I will be presenting information and I will place a complaint with the governor and the attorney general's office as to all the things that continue to happen. So, thank you.
Okay, and if I may as well, Chapter 1001 Florida Statute, enforcement of laws and rules requires that all laws and rules of the State Board of Education or of the district school board are properly enforced. We make all these processes and procedures, and we make sure that we put them in place. However, we choose only to apply those to others. And I think that's really important that we make sure that we are adhering. And then we need to make sure also, and that's in policy 5.331, we also have on here, it says, neither the school board superintendent, department heads, nor principals, nor any employee shall take or recommend to the school board or take adverse personnel actions against any employee or disclose information pursuant to the provision of this policy. So we have things in place in our policies that we wrote, that we agreed on, that we voted on. So I hear what you're saying, and I thank you, but I'm just trying to make sure that all the information is in front of you based on the policies.
And can I just say the last part of that, though? When does our policy that we write override statutes from federal? And I'm just looking at federal, so I mean at state. So I'm just saying, that's what I will be doing.
Ms. Fisher?
Based on the comments of my colleagues, I'm just going to wait in abeyance because I do think, contrary to what I said at the last meeting we discussed this at, is that we do need a broad investigation with an independent external investigator.
Thank you.
And did you, I'm sorry, and did you read a part that said state and local government can assist in that?
They are the, that they have the authority to investigate
They
the
do.
school board. Yes.
Okay.
Yes, they do.
May I just ask a question on what she just said?
No, right now, I'm sorry, we cannot, because I'm going down, making sure that everybody has their opportunity. Thank you, Ms. Kittens.
May I ask a question through the chair to Ms. Morgan? To clarify what we're discussing?
Okay, what we are discussing is the lighthouse and the broad scope of what I had read. What I would be asking for, and again, it's not about an individual member. It is about, it's the scope of everything that has taken place, including everything. The 219 text, who knew about it before it came to us? Who knew about it before it was sent out? Who is involved in all of this? Who are the law enforcement agencies that are involved in this?
Excuse me, point of order. I was going to ask a question and you allowed Ms. Patrica to ask a question?
I'm speaking the answer.
No, I said, may I ask a question on what she said? She says, can I ask a question? And you allowed her to ask it and you're going ahead?
I'm referring to what it was that I spoke on. Thank you, Ms. Gittens. Any retaliation, if there were any claims attached to this, all information related to this matter, everything, including witness tampering, so everything. So we can have a clear understanding of what actually took place and be done with it.
I'm right there with you. Ms. Morgan said the board. I wanted to make sure it was inclusive of the entire leadership team and the board attorney, and that's what I heard you say.
It's everything.
Yes. Thank you.
Well, I've read everything, and it's like triple hearsay. So what is the merit here? That's what I'm trying to figure out. What merit do you want to have an investigation on? I don't believe anything that I've pretty much read, actually. So I'd like to know what merit, because, I mean, we know that there's not an investigation now by law enforcement. So now we already know that answer. So I'm having a hard time understanding we had several, including the superintendent, that mentioned law enforcement. So I think that those questions need to be answered, and they should be answered right here at the table. And then as far as, I don't understand, like I said, merit, I don't see any merit here. All of it is hearsay. And how do we do investigations on hearsay? I mean, when do we not use our intelligence and make determination based on reading and based on that? I mean, because at that point, I mean, first of all, I do have one question too for the attorney. Define what is a whistleblower, because I don't believe that the whistleblower that claims to be whistleblower that doesn't even have merit. We have no control over employees, so there's no point in that. So that's one question I have.
So, but right now we're speaking on the lighthouse, and then we'll go into that second one, which will be that one. There's 2 complaints.
Okay, well, the lighthouse, then hold that thought. Back what I said is that I just don't see the merit of that at this point, because it's hearsay. I don't think you do investigations on hearsay. You don't in the court of law, so I don't know how you do it in here, so. And I guess I'll just leave it at that, because honestly, if you're talking about the investigation, regarding the lighthouse, should go back to October, because that individual was in a complaint back in October, so it should go back all the way to October, and when this started. So I would add that date then.
Yeah, and I'm trying to make sure that it encompasses all of it. Okay. And Ms. Gittens, you had something else to say?
I do, but I mean, I'm just floored. That behavior of this board and of our leadership. I really am. And when you go back and watch the video of this meeting, you will see that Ms. Fisher made a statement. I asked a clarification. You told me no. Ms. Patrica was not called on. She asked for a clarification of something said earlier, and you told her yes, and you went on and did it. So I just want to have that on the record. Part of this investigative piece, I mean, I've told you all already, the next step is going to be who is going to do this investigation. Seemingly you've already made up your mind that you're going to do that. And I think we are wasting, when we talk about waste, fraud, and abuse, we're wasting so much time away from children. Several, people on the board from time to time, what does that have to do with children? What does this have to do with children? And like Ms. Melissa said, it's so much of it is hearsay. It's like apparently and maybe and all of that. So if there is extremely, it's extremely obvious that people involved in all of this, every time there's too many questions or there's quote unquote badgering or getting out of line or getting out of your lane, we suddenly have an investigation. Taxpayer money is being used, will be used, unless, if you're going to do it, have the state do it and have the state, they will pay for it. The government will pay for it. I am not going to go along with anything that is a witch hunt and have the taxpayers of Lee County pay for it just because someone doesn't like what someone else is saying. I mean, I could have, the behavior that I have received in 2.5 years, I could have done all kinds of complaints. But we don't have time for that. We have children to educate. And I just think this is a frivolous witch hunt, and I base it too on our last discussion about this when Ms. Patrica and the superintendent said, well, we need to get to the bottom of this, finally get to the bottom of who is doing this. And the superintendent said the same thing. We need to find an answer once and for all. So it's a witch hunt. So I will not be participating in it.
Thank you. And Ms. Gittens, this has been put onto my shoulders because of the fact of this one and the next one, because of the people that are involved in it. So that's why I was then given this to do. And that's why I called, and we have a different attorney here so that we can have clear eyes and we keep everything where it needs to be. None of us have gone through this before. So this is not a witch hunt. This is something that we have to do, to speak about, and that's exactly what I'm bringing here to the board, is to speak on this. Ms. Giovanelli.
So my question is, why are we having an investigation? What is the violation? And then I think you're going to say the violation is releasing that text, but that text was a blanket response that you yourself, Ms. Jordan, have given to the public. So if that is a violation, then you would have an ethics violation against you because you gave that very same blanket statement about someone under investigation while there was an investigation. So what's the violation?
Okay, Ms. Giovanelli, let me clarify that for you. Before I speak to anyone, I always call to make sure what we are able to say and not say. First of all, I always follow up with that. And as well as nowhere did I ever mention a person, school, or anything. Never, ever. All I said was there was, yes, we recognize there was something, and yes, we will investigate just like we do anything else. That is a blanket statement. Does not put anybody into anything. And as far as hearsay, witch hunt, and I'm sorry that, people are, I actually read information, so I'm not sure where the hearsay came into play. It's what I read. And it is my job as the chair to bring this before you all. And I felt like I needed to do that. And so that is why we're here. We do not have to do anything at all. Nothing. If that's what we choose to do. We can do absolutely nothing. Just say, okay, whatever we do is fine. And we just go on and live happily ever after. That's not going to happen. But what I need to say is we have that option. Or do we investigate, and get this all cleared and out of the way so we can get back to what we really need to be doing, as Ms. Gittens so, kindly spoke about. So we do have things that we have to do, and we are wasting a lot of time on things. It seems like every meeting we have, but we need to get focused and bring it back to why we're here and what we're supposed to be doing. So that's why I'm bringing this up, and we would definitely have to I would recommend an outside investigation, no one from within here, so that there's no ties, and then it's done, it's over. We're finished. So that is what I'm asking today. Do we have a consensus that we move forward with this, and I can speak to, and have this conducted with an external investigator to take care of this? And then we're done. Ms. Gittens.
Are you saying then if we move forward that you as the chair will select the investigator?
I am suggesting that you allow me to speak to them.
To select the investigator?
To select the company to do this.
I will never agree to that.
Ms. Fisher.
So in regard to Mrs. Giovanelli's comments and your questions about who was aware before the text was sent and what exactly is the involvement of law enforcement since February 19th, what were any communications between board members and staff, and what was the outcome of that? And then has there been any retaliation? So if we spend maybe $50,000 with a company, an external investigation, when potentially we could get the answers to these questions here and now. I mean, so I guess that was a good point that she made. So is that something that could be requested and get it resolved at this point? Or should we use the state investigators? I'm just looking at both suggestions, and have the entire situation and all of the details that are mentioned in the Lighthouse complaint investigated by the governor's office.
And I would caution us having a lot of conversation up here regarding, because I don't want anybody's names to come out or things that could potentially come back to against the board as well. So, Mr. Quick, could you?
No one's saying any names.
Could you please respond to that as far as being able to get the information pertaining to this claim, this potential claim? Would you advise us to have that conversation sitting right up here about that?
You know, I would not advise you to do that as a public discussion. If you were going to do something like that, I would probably ask the superintendent or somebody, or even an external investigator, maybe have that be his or her first step to inquire, and then if that's unsuccessful to the board's liking, then you can decide how to proceed, whether it's proceed with investigation, not proceed, or refer it to another agency, which was also mentioned.
Okay, so you have heard the attorney's recommendation. Ms. Gittens?
Okay, in all that I have read, there are individuals within this organization that have all the answers to the questions that you have stated, and they have even said that they have it. So again, I'm asking, why are we spending time and energy? Why can't we just make a consensus that we be shown and shared the answers and the information that is out there with no cost to the taxpayers, and then decide, okay, if from that point, if we want to investigate or move something along with one of the people on the board, it was specifically stated that one or more. So there are people that know all the answers. Why are we spending time and money to find the answers that we already have? We can provide all of the information to each of us and then be able to make a decision. Do we want to take this any further to prosecute anyone? But I think
Well, let me clarify something. We're not trying to prosecute anyone. That's not at all what was said.
So what's the outcome?
We're not, do we want to go through this? And yes, we do need to find out what the outcome will be. What is the outcome? Is the outcome just to say, okay, now we have all the information, it has been cleared, and we move on, so that it's not a hearsay, or we're not thinking that we're reading something that we're misreading, that we have somebody who has no attachment that can actually look at it and say, okay, no, this is a bunch of whatever, malarkey, this is what we need to do. Because, and again, it's going to come back to us again. What is it that we're going to do with this? It's going to come back to us. We're not wasting our time because somebody else will be doing this.
But if I have all the information that is alluded to, that is out there, I don't need a third party to give me something to read. I can read. So I'm just asking for the board to allow all of us to read all of the information so that we are privy to what's going on.
Mr. Quick?
Madam Chair, I would say, the board does have has employees in the superintendent or the board attorney that, to the extent that he or she has that information, and the board can direct that to be shared with the board. Right. That is something, should the board choose, they could, or obviously if they could get it or have access to it, that's something they could do. The board could ask for. Obviously, if this gets referred out to an investigator, the investigator would be presenting this information as well as obviously interviewing and things like that. So you do have two employees that should you wish to direct, you could.
Okay, so hearing what Mr. Quick had said, and again, we have had the opportunity to read. So I guess my question is, we have the opportunity to get information from the superintendents or the attorneys. However, we actually read something that came through our hotline that we created for the purpose of getting information. And we've read that, but the way that we read it is we each interpreted it differently. So how do we interpret what will be given to us the next time? Then we come back and have the same conversation again. Yeah. So that's where I'm trying to put this together.
But that complaint said there was it reported to law enforcement. We have to let law enforcement do their job if that's in fact that case. That's what I said 2 weeks ago. I'm going to say it again. But we know that that's not true, because we've got information since then that says there's no law enforcement involved with anything. So I think that we have to use our own brains and figure this out a little bit. And I don't think we spend taxpayer dollars. I would agree we can let the Tallahassee do it, the officer, their OIG or whatever. We can kick it to them, and they'll do it at no cost. Or we wait for our local law enforcement, if that's what's happening, deal with that and let that. So the Harns Marsh case, they were instructed to not have to do any investigation. This district was not, and they couldn't until law enforcement finished their investigation. And that is the way it works. So we should not be getting involved in anything if law enforcement is involved, period. And once that's resolved, then we can move forward and make some kind of decision on the outcome of that, I think. We need all the information, and we do not have all the information. We have part of it. We have what's been selected to give us, and that's biased at that. So let's get the information from an unbiased party at this point, and I will gladly wait on that, and I will gladly make a decision once we have the real information.
Okay, so Ms. Morgan.
So, following up on what Ms. Giovanelli said, unbiased is what we need. This is a board that doesn't trust one another. This is a board that has expressed lack of trust in staff. So for us to proceed trying to pursue this internally is going to lead us right back where we are now. I just believe that we have developed a culture of action and engagement that works against our ability to work on behalf of kids. And I think the only thing that is going to help us get back on track is an independent investigation that says there is something here, or it says there is nothing here, and then we can move on. So that's where I am.
Okay. Is there any other comments?
Yes.
Further comments, Ms. Gittens?
I would like to request, as per what Mr. Quick said earlier, that we, as a board, direct the superintendent to direct his staff to give us every bit of information regarding both situations and the 219, so then we will have in our, and not an interpretation. And I really disagree when you have things with words like apparently and maybe and, you know, I assume. I want to see the whole investigation. I do feel that we are intelligent enough to read not just selected information, as Ms. Giovanelli said, but all of the information, and then we can make a decision. I do not think that we have been given all the information. And after that, then we can make an educated decision on what you want to do from there. And I agree that if we do move forward, it has to be done through Tallahassee.
And Mr. Quick, can you please, I know like in 5.31, it states that about the superintendent not interfering with investigations. I'm assuming that school boards cannot interfere with investigations as well. Number one, could you answer that one?
That would be correct. If
Okay.
you're going to be investigating, it will be, I mean, obviously, given what's being discussed, I assume the investigator will want to speak with many of staff and the board members. That would not be considered interfering, but yes, you would not be, there would be no interference, yes.
Thank you. And then on our, and I also want to remind everybody too, regarding our hotline and Lighthouse, it says that once a complaint is received by the hotline, it will be directed to the appropriate department, either the internal auditor or human resources. Legal services will also be involved in directing the complaints to the appropriate departments and help determine legal sufficiency. So this first one that I'm speaking about, it came through the hotline. It's, again, it's our hotline. It's our, something that we put together for this, for cases like this. So how do we, as a board, say, we have a hotline, but we're only going to use it for certain things? How do we do that? That's my concern. Ms. Giovanelli?
This complaint just came in on the 8th, not when we had this same very discussion, and so this came in on the 8th. We don't have that information from when we had the discussion on the 8th. Prior to that was the same information, same topic. So it wasn't the Lighthouse, but it was the same topic, same players, so and individuals. So I think that we need that information to even make the determination of this information. So,
well, to your point, how do we know? I had no knowledge of the people in the Lighthouse. I had no idea about that, none whatsoever, when we were having our conversation, because how would I have known that? That was not discussed. We didn't have names or anything about that. So in reading, that's when I received information.
The complaint actually says that. We were talking about her. That's why. Mm-hmm. So that's my point. This same thing came up before we even had all the information. That's my point. We didn't have the information. We had this conversation already. Gotcha. How silly. We're being silly. And we're wasting tax dollars again on something that and grandstanding and wasting time when we can be doing the business of the district and teaching and educating children. This is all about children. What we're doing right here is not about children. It's about a dysfunctional board that wants to continue these activities and all to get their own way. It's all to get their own way. And you know what? A board is not about getting our own way. It's about working for the best interest of children. And this is not.
Thank you. Ms. Morgan?
Yeah, so I'm reluctant to say this, but we put a question out. We were to poll all of the board members once. We have. Have we got an agreement amongst the majority of the board members to pursue that action? If yes, that we've answered the question. If no, we continue the conversation. Other options have been raised. I just don't know where to go with this, but we're all over the place and we're not getting anywhere. And we're going to continue this conversation for another hour and run into our next meeting.
Thank you.
I would like to see a way to put things out there that we can say yes or no and then move on to the next step.
Okay. Ms. Gittens, I'm going to let you finish and then I'll.
Okay, all I am asking for is, I want to see all of the documentation. That's all. I cannot, when you talk about, a report to Lighthouse is just a receptacle. Someone calls in and says what they think, feel, and believe at this point in time. Then that information is looked into as to whether it has credibility or legs to walk or whatever. And if we are basing all of this, how many times do we get, I looked at the report from Lighthouse, and I think there was something like 74 complaints that went into HR, and 73 of them were investigated. And it was compared to, what was it, Osceola or somewhere, they had 62 complaints, but it didn't say how many were investigated. Lighthouse is the receptacle for people saying, I've been hurt, I've been damaged in my interpretation. It is the start of deciding, is that actually true? And we're jumping over, taking what someone said and going to this leap of spending $50,000 or whatever it is to investigate. It is a Lighthouse complaint. It has not been verified, and I haven't seen all of the information. I want to see what is alluded to in all of the complaints.
Okay, thank you for that. So based on the conversations that I'm hearing, no one's wanting to spend money, so do we have an appetite to send it to the state for investigation?
Excuse me, I'm not, I think we need to take a consensus on the first question before we talk about sending it to the state. And everybody's had multiple opportunities to speak. May I?
Yes, please.
I think that the difference between what we're talking about here, the complaint that came in versus another complaint that would come in through Lighthouse, is this one is specifically directed at the board. Staff can't investigate and determine the legal sufficiency of something that comes in through Lighthouse when it's directed to the board. And that is why an outside determination needs to be made with regard to that. And I fear the round and round and us never really emerging from the hole that we're in if we don't take this step as a team together.
Okay, so
thank you.
Thank you. So
I have a point of order on that one. That is incorrect. We have an internal, may I finish, please? We have an internal auditor that if something comes into Lighthouse, it is either waste, fraud, or abuse. If it falls into that category, it goes to our internal auditor to investigate that. Look at the policies. That's what they are supposed to do. We're not supposed to jump over them.
Correct. Ms. Gittens, I've spoken with RSM as well, and that is something that they can investigate, but because it is a board, they have an issue with that as well. So I'm going to go back to, everyone did have an opportunity to speak, so I'm going to go back to the question on how many would like to see proceed to have an internal investigation, whether it's RSM, someone, do this so we can be done once and for all, and everything will be clear, and it would be everybody.
No, I thought we said external.
I'm sorry, external.
Okay.
Did I say internal?
Yeah.
I apologize.
Independent, external investigation.
Independent, external.
Chosen by the chair?
I will send the recommendations to you all. Or I can come back and share that with you at the next meeting.
Would you be working with Attorney Quick
I would work with Attorney Quick for that, yes.
for independent?
And he has, yes, we've already spoken about that, if that was okay with everybody.
There were already suggestions that were presented by
Okay,
another
but I'm going
attorney.
to, Ms. Gittens, I'm going to go back to the one that was on the table that we,
No, I'm talking about the external. Mr. Williams submitted some possible names of ones. Are those the ones that you're going to look?
I haven't seen those, and again, I would be willing to work with Mr. Quick on this. So do we have an appetite for having an external investigation to resolve this? So we are.
And what is the budget? How much are you willing to spend?
As little as possible.
We need something on the record. There must be a limit or something if you're going to do this.
What amount would you like, Ms. Gittens?
I think
speak
zero, because we can do it through the state if it's a must. If we cannot get the information we're asking for to look at on our own and then make this decision, then it has to be a zero. I do not want to spend.
Ms. Morgan?
Yeah, so Mr. Quick, what in your experience would an investigation of this sort, and I'm not going to hold you to the dollar amount, I just like to have some general idea. Are we talking 5,000, 10,000, 100,000?
And thank you for not holding me to it, because when I look at this just with the number of potential people that need to be interviewed, my guess would be somewhere between 20 and 40,000. That would be my guess, my best estimate.
And then following up on that, I would say that in order to regain the trust and confidence of the community and staff, I would be willing to expend something in that neighborhood.
Thank you. Okay, so could
waiting for
could we please then have a consensus on allowing this to move forward, and with the scope, and if there's a broader scope, I will definitely keep everybody informed of what that is, to make sure that everything is covered in that scope.
And can I just note that we weren't willing to spend $25,000 to regain the confidence of the community on another issue.
Thank you, Ms. Gittens. So may I please have a consensus on moving this forward? Ms. Giovanelli?
No.
Okay, it passes. So, Mr. Quick, I'll work with you on that.
And may I ask Mr. Quick a question?
Yes, I'm sorry, Ms. Gittens, could you please
Regarding
raise your
the
hand, and I
vote.
will be
Okay,
more than
may I
happy to
raise my
call on
hand?
you. Thank you.
How, a year ago, started talking about not doing so many consensus votes because they're not hard votes. And we're moving more and more and more into consensus. A consensus vote is not a hard vote. And when we're talking about spending taxpayer money, we're talking about all of the people that will be involved. I mean, we've got the superintendent, various staff members, all of this that will be taking time away from children. And we're doing this with a thumbs up consensus vote. How does that, can you weigh in about consensus votes versus a hard vote?
Yeah, I mean, I don't want to. I haven't been following over the past year to see how how much you all have been utilizing consensus votes to make certain decisions. So I don't want to step on anybody's toes in terms of current or past practices. But obviously, a hard vote at an action meeting is binding on the board and you are subject to that, and, you know, the only way you could go back on that would be, you know, certain ways to rescind or reconsider motions, and there are limits as to how that could happen. So there is a different character, it's a different character when you have a motion, second, and vote at an action meeting, if that's what you're asking.
It is. And Ms. Jordan, can you please then just reiterate, since you said, did you say it passed?
I'm sorry?
Did you say that it passed?
Yes, I did.
Okay, so would you please
We have
reiterate
consensus.
specifics as to what it is?
We have consensus that we move forward with an external investigator to review the Lighthouse complaints with a broad scope, as broad a scope as possible, starting with and before 219 texts, who knew about it before the text was sent, what involvement, what is the involvement, who are the law enforcement that are involved, who shared the text, if any retaliation, if any, claims attached to this, all information related to this matter, everything, including witness tampering.
Can we say independent, external evaluation? Because we don't want somebody who has prior connections with the district.
Yes.
Can we use, you mentioned RSM, I'm sorry, I'm raising my hand.
Please, Ms. Gittens.
Okay, you mentioned RSM, and they are our internal auditors, so perhaps if they are not willing to do it, they could possibly provide examples of people that could.
Yes. And they will. They will have some.
But is that your first step, or you
Yes,
want?
I will speak with Attorney Quick as well as RSM.
Thank you.
Thank you. And the next one is regarding a whistleblower complaint. Under policy 5.331, let's see, there are certain things under there that we must do. We must do an external investigation under that policy. The key words from that policy too are will promptly occur and shall acknowledge. And based on that, that is something that we would need to make sure that we are taking care of that. And then, because of the fact that it says that any retaliation against a school board member shall be given external investigation for review, so, or that involves a superintendent, an attorney, we have to remove them, and that's how I wind up in
I'm
it.
sorry, are you on policy 5?
I'm on the next 5.331.
There's two policies at play here. 5.331, sub 12.
Yeah.
A talks about the mandatory nature, where it says that any complaint of adverse personnel action or retaliation will be promptly investigated. And then the other policy is the one that we were looking at before, 5.311, which is the one that talks about that the investigation needs to be done by external investigators. And that's under sub 6, which specifies the reasoning behind why that would have to take place.
Right. Ms. Patrica?
This is the one that I really needed help with from Attorney Quick, may I?
Yep.
So what's your recommendation here for the board to be in compliance with law and policy?
I think you have to investigate it, and I think you have to investigate it through an external auditor.
And would
or
you-
external investigator, sorry.
Would you be in a position to provide recommendations for the chair to work with you to determine who should do that?
Yes, I can speak with the chair about external investigators. Yes.
Okay, so I'd like to make the suggestion that we do a round of discussion regarding. Do you have it written down, or do you want me to say it?
No, based on policy 5.331, any complaints of adverse personal action or retaliation will, which will is mandatory for us, be promptly investigated, and a receipt of the same shall be acknowledged within 5 business days. If the employee's allegation of adverse personnel action or retaliation are substantial appropriate corrective measures shall be taken by the superintendent and/or the school board.
So is today appropriate acknowledgement? Is this meeting acknowledgement within 5 days?
I believe it was acknowledged by, upon receipt already, but I will double check to see, I have it here, I can tell you if today would also be, it's beyond the 5 days, but I believe it was
The legal
acknowledged.
requirement of acknowledgement has been met?
Yes, I believe, it's my understanding
so
that that
can-
has taken place.
It has
We have
been.
a round of discussion regarding sending this to an external auditor and relying on the chair to work with Attorney Quick to determine which external investigator should handle this.
Perfect. Thank you. Ms. Gittens?
Okay, in my estimation and my lack of legal knowledge, both complaints, both issues, all have to do with February 19th. Am I correct?
Yes.
That's my reading, that they all stem from.
Stem from February 19th.
They are separate complaints, separate and distinct complaints, but they do all stem from the same underlying facts, yes.
So if the board has already decided to investigate, why would we not have one investigation of the February 19th issue, which would include all of this? I don't understand, because the whole thing is the validity of the February 19th text. That's the bottom line to both complaints. And if there is no validity to that, or if it's not proven, then we don't need to spend the money, the time, the energy on two separate issues when that's the crux.
Can you explain, because it's two totally separate.
Yeah, I think they're going to be, they need to be done as two separate investigations. I think I understand what you're saying, Ms. Gittens, which is why not use the same person for both? And I think for financial reasons, that would probably make sense. But when you're talking about like the whistleblower issue, and this is to get to Ms. Giovanelli's a point that she had asked before, a whistleblower and whistleblower retaliation have different elements or additional elements to it. And you're talking about, for a whistleblower, you have an employee who disclosed protected information and then had some sort of adverse employment action, and there's a causal connection between those two. So protected information means, potential violation of the law, malfeasance, gross mismanagement, things like that. Adverse employment action is, what you, I think you imagine, terminated, demoted, a number of things. And then there's a causal connection. So that's why they're separate investigations. They are linked because everything kind of started with the 219 issue. Mm-hmm. But they are separate complaints and separate investigations.
Separate ways to deal with them. Okay, I get that. So with the whistleblower one, is the litmus test adverse employment action?
That would be one element that would need to be required for there to be whistleblower retaliation under Florida statute, which is adopted within your board policy as well. So yes, that is an element.
And see, in my estimation, no one's lost a job, no one's been demoted, no one's had a letter put in their file, no one's had anything done.
Okay, Ms. Gittens,
I'm
yeah. I just want to make sure that we're careful. No, I'm not asking you to stop speaking. I'm just what
I'm
you're
not going to say anything.
Thank you.
I understand.
Thank you.
That I am not supposed to be specific.
Thank you. I just felt like when we're reaching into what has not happened to a person, we don't know any of that, so we should not be speaking on that. Am I correct?
But if moving forward on an issue has to do with adverse action and no adverse action has occurred, then what's the issue?
And ultimately that will be for the investigator. So there has at least been an allegation of whistleblower and retaliation. Whether that's sufficient, if you want to liken it to like a complaint in a court case, somebody can file a complaint, but at the end of the day, you have to prove it in order to prevail. So there has been an allegation. It does need to be investigated under the policy. Whether the facts, and I'm not going to discuss the merits of it because there would be a lot for an investigator to do, but ultimately the facts would need to establish everything for a whistleblower retaliation.
So may I put it on the table then to do a consensus that if we're going to have an investigator for the other complaint, that the same investigator do both? And perhaps we can save some money.
Thank you. Attorney Quick, do you have your thoughts on that?
I mean, I think you can have the consensus would be, number one, to proceed, which, as I've said, in my opinion, I think you have to.
Right.
And then the other consensus would be to utilize the same investigator so as to not duplicate efforts and try to maximize time and cost.
Perfect, thank you. Thank you, Ms. Gittens. Ms. Morgan?
I support it.
Ms. Vaughn?
I support it.
Thank you. Ms. Fisher?
Yes, I support it.
Thank you.
May I ask a question of Attorney Quick?
Yes.
I'll be quick. You don't see any issues with the same investigator handling both?
I don't. I mean, as long as they treat them as separate and distinct complaints and investigations, I don't.
Okay.
Ms. Giovanelli?
I support it, but I have to ask the question. So once this is resolved and there's been no whistleblower retaliation, what are we going to do as a board to deal with this situation that this complaint came up? I think it's really important that we have an expectation. We just can't drop it and pretend like it didn't happen or that we didn't do this investigation. We have to have an outcome. So, and that's really important because there's been so many complaints that's come through here, including whistleblowers, that's never been addressed, ever. So now we're setting the tone and precedent that one matters because of it coming from a certain department. So I think that we need to really, I'm not against it because I think we're forced at this point, but this is going to continue to happen. Just like this has become a pattern and it's continuing to happen. And so how long do we not hold anybody accountable for that? And we know who we have to hold accountable. Thank you.
Okay, and we need to be very careful when we're speaking up here that we're not insinuating anything either. So what I will say, once this is completed, then we will be bringing it back here, and at that time, a conversation will certainly take place, for sure. And this is something, as I stated, it is in our policy, so this is something that we have to do this. Ms. Fisher, did you have one more?
Yeah, I just, regarding being careful when we're speaking here, this is our place to speak. This is the dais, this is in the public and in the sunshine. This is the place where we can speak and get information out on the table, because we can't do it elsewhere and otherwise.
And I apologize, I'm not saying that I don't want anybody to speak. I'm just saying when we are speaking, we just have to make sure that as individuals, I mean, you're welcome to say anything you want to, but I'm just saying, as individuals, you might think about, the adverse effects that it could have on one or all of us. That's the only thing that I'm sharing. I'm putting that out there. But again, you as an individual or whomever can speak and say whichever they'd like.
Right, because the public expects transparency.
Yes, ma'am.
Just as a reminder, I think also part of the being careful, at least what I understood from the chair, was in terms of utilizing specific names and identifying, not just names, but other ways of identifying the people that may be under investigation or the people who may be claiming whistleblower protection. So I think that's just to keep that in mind as well.
Thank you.
Thank you, Attorney Quick. And I also agree, I'm going to finish with the agree. So this will take, did you have something to add to this, the vote or the consensus? Please, Ms. Vaughn.
I agree with what Ms. Giovanelli said, that once, and that you said, I just want to reiterate, that once we have the information, but in the interest of time, what I would like to see is a definitive action from us, or a directive from us, with the idea that once we have all the information, then we will be able to judge what would be appropriate to do with that information. I just wanted to reiterate that.
Thank you, Ms. Vaughn, and I totally agree with you, and I think that's something that we absolutely must make sure that we do. So, Ms. Giovanelli, and then we're going to close
This is actually for a question for Mr. Quick. What's a reasonable amount of time that this would take? Because we have to have some kind of expectation. If this is going to take longer than, let's see, if it's going to take longer than 3 months, there's a lot of things that happens in 3 months, so we'll need to postpone those things until this is resolved. And so that's another thing that I would like to recommend, that no actions taken, or that we make no decisions on any evaluations until this is complete, this investigation is complete.
Okay.
Your board policy.
This is off of, our board policy dictates to us when we have to do evaluations.
Well, your board policy dictates evaluations, and your board policy also sets out timeframes for investigations. I believe it says 60 days,
Yeah.
although it can be extended depending on, for certain circumstances,
Okay,
number of witnesses, complication. But you're looking roughly, I think that probably your idea would be looking
2 to
at
3
done in
months.
this, 2 to 3 month time
Yeah.
period.
Okay, so I will, I'll make a motion tonight at the table that that no evaluations will be done until these 2 investigations are completed. And we've made a determination on that. So I'll let you know that right now. So I'll be making that motion tonight.
Tomorrow night.
Tomorrow night.
Tomorrow night. Thank you.
Okay.
Yes. Marty.
And I have a
Thank you.
question for Mr. Quick, if I may.
Go ahead, please.
It's me, huh?
Well, okay, in the conclusion of the whistleblower, I know that the board cannot direct the superintendent to do anything with staff. That is his, thing to do. How would that work after the investigation? Is it still up to the superintendent, depending on whichever way it goes, to make a determination how he's going to handle it?
So your role, you still control the superintendent, your employees, superintendent, the board attorney, things, but the superintendent in his office makes determinations on personnel actions. I will also mention that under your board policy, somebody claiming whistleblower protection is entitled to certain, or it's claiming whistleblower is entitled to certain protections. This is under 5.3 sub 13. So there are, if they make a good faith reporting, they are entitled to certain protections under your own policy. So obviously anything would have to comply with the policy as well.
Even after the investigation?
Yes, so the way it reads is that if you make a protected disclosure, that the policy says the policy does not immunize an employee, volunteer, or student from the consequences of his or her own actions, which actions do not constitute reasonable and good faith disclosure of the type of information described herein. So if it's a good faith disclosure, they're protected from employment impacts of their decision. If it's not a reasonable good faith, and that's the term from your policy, if it's not a reasonable and good faith disclosure, then that provision, as I read it, would not apply.
Would not apply. And in the past, when we have received whistleblower requests and we did not act on them according to 5.331, were we out of compliance with our policies at that time?
This policy was enacted in October, from what I can tell from your board policies.
October 6th.
So if it predated October, you would not, October 6th, if it predated October 6th, this policy would not have been in place. If it was after October 6th and it's an employee whistleblower claim, and it's important to say that this does talk about employee whistleblowers, then you would have to and would have had to done it. So if predates, then no.
Okay, thank you.
And it specifically states if there are certain people involved in it, we have to do this. So thank you very much for allowing me to speak on this today. And Ms. Giovanelli?
So are we receiving all whistleblower complaints straight to the board now, if it's on board members? And we've received, to date, we've received every one. How do we know this?
Are we receiving all the
All of them, because this is the first complaint. This was one of it was important to note that the board attorney mentioned that she received only one. This is the first complaint she's ever received, a Lighthouse complaint, and that was this one. So I'm concerned that we're not receiving the whistleblower, all complaints, or that ones that are supposed to come to us that would be under our purview is what I guess I need to rephrase.
Based on our policy, it says that, and this is a conversation that I had with our RSM as well. I was going to share it later, but based on our policy, Lighthouse is supposed to be sending us every 30 days an update, like a list of calls. So we are supposed to be receiving those. And we have not, at this time, because I have not seen them.
Right.
I don't believe
That's my
anybody
point.
has. So, and RSM has not. So I definitely had spoken to Dr. Atkins about this as well, to get permission to speak to, make sure that I spoke to Dr. Pruitt, so that way we can make sure that Lighthouse is sending all that information to RSM, Ms. Dupree Bruno, and for us to have that information, the report. So they will be coming to us.
And also, just to follow up, in terms of specific complaints, there are certain, depending on who is involved in the whistleblower complaint, is whether it comes to the chair or whether it goes to the superintendent. So,
Or the board attorney,
Or the board attorney,
because it says there's the legal team or whatever.
She will be receiving them.
Yeah.
Our attorney will receive that, correct.
Well, that's my point, is the attorney stated this was the very first complaint Lighthouse complaint she's ever received. So that calls me for pause and a little bit of alarm, and that this board needs to have this conversation, because I think we have a little bit of a disconnect. And I mentioned this a couple weeks ago because I've already had complaints about the Lighthouse process. So obviously there has to be some issues going on with that, and I don't know where that is at, where it lies, if it lies at the communication aspect or if it is in the house, but we need to know, and we need to get that resolved. And we can't sit up here and not get some answers and do some directives. Thanks.
No, thank you. And as I said, I read this whole policy several times over the weekend. So yes, we are supposed to be receiving that. I did bring that information to RSM regarding the language issues that you had stated. So they are very much aware of that as well. And so that is going to be mainstreamed, and we will be getting that information. RSM will be receiving that. Ms. Dupree Bruno will be receiving that. So, and then we will have like a list like we do for public records, just of how many, so that way we are kept aware of what is actually taking place. Ms. Gittens.
And just for the record, several months ago, I did request that and nothing was done. And then we just recently got a list that has everything in it. When I asked about it last fall, we got one list and it only had some things on it. It was not a complete list. But I will say that the last one we received, I just looked at it and it does have everything on it.
Thank you. Yeah, so we are definitely working on that. And one more question, then we're going to close
And I'm
this.
sorry, but we received the two lists, I think January and February, and they're coming in our updates. And I understand, but there's a lot of information that's in updates and that gets overlooked. And I think that this is very important, and that this should come separately. And that's another recommendation that I would like to have, but we can save that for
I hear you.
a Lighthouse conversation, because I'm hungry.
Okay. Well, now that you're hungry, we're going to close this meeting out, but we have another meeting which starts at 9 minutes. 1 o'clock, we have another
I have to
workshop.
get food, so I've got to get something to eat.
Okay.
I will be late.
Me too.
So this meeting is adjourned.
Can we make
Chair,
an
if I may.
extension for the next one?
I want to say it was nice seeing you all, and thank you again.
Thank you so much,
Thank you,
Mr.
John.
Quick. Can we do that? Can we do an extension?
It's all right.